Are we expecting anyone else?
My lord, I think Mr. Shaheen is there, but I don't know if his video has been activated.
Sorry, who's that?
Mr. Shaheen, counsel for D2 and D5.
Yeah, Mr. Shaheen, I can see.
Yes, Your Lordship, I'm here representing D2 and D5.
Yeah. Very well, if everyone is here, then shall we begin? Mrs. Khan, are you going to call your witness, or is there anything else that needs to be dealt with beforehand? Sorry, can I just say before we start, I've considered further the matter we discussed yesterday about the conflict of interest. The matter is complicated. I'm going to reach my decision and give reasons for it in my judgment in this case, but we will continue with the case in the meantime. Thank you.
I am deeply obliged.
Right. Now, Mrs. Khan, are you going to call the witness, or is Mr. Vajani going to call the witness?
I'm going to call the witness.
Yeah, Mr. Vajani then.
Yes, with your lordship's permission, if I may call the first witness, Mr. Chizian.
Excuse me, Your Honor, may I?
Of course.
Yeah, actually, without this issue of conflict being decided, I think this whole trial and the way we will be proceeding will be prejudicial to my interest. And to be honest, we've already seen a few examples of it yesterday, where the confidential information provided was being quoted against against myself. So may I humbly request that this matter be decided before we continue further, because I understand it is complicated, but it is definitely something which will be very prejudicial to me.
Yeah. Well, I'll tell you, I've made a provisional decision, which is this: that as at present, I do not see a proper basis for discontinuing the trial. The reason I haven't made a final decision is that things may develop during the course of the hearing, which lead me to a different conclusion. But at the moment, although I understand the complaint about the conflict of interest in the past, it does not seem to me likely that it will affect the future conduct of this hearing. As I say, the reason I'm making a final decision is that things may happen during the course of the trial which lead me to change that view, and they can be raised by parties either at the time or better in final submissions. So that is my question. Thank you. Right. Mr. Vajani, you're going to call Mr. Chezian.
Yes, with your lordship's permission, by me.
Very well. Are we going to try to stick to the timetable, although 1 hour earlier? Yeah, very well.
That should be the endeavor, your lordships. That should be the endeavor. Mr. Chizian, your lordship's permit. Mr. Chizian is on the screen now.
Are you Mr. Chizian?
Yes, sir.
You're very blurred on the screen. That's better. Can everyone see Mr. Chizian? Yeah, very well.
Your lordship's permission, may I begin his examination in chief?
I'm going to ask Maitha to administer the oath.
Yes, Judge. Good morning.
Good morning.
Mr. Chizian, would you please state your full name and occupation?
I'm N. Cherian, currently posted as Regional Head, Union Bank of India, Chennai.
Thank you. Would you please confirm if you'll be taking an oath or an affirmation?
Yeah.
An oath or affirmation, please.
All facts and matters mentioned in my witness statement are true to the best of my knowledge and belief.
No, Mr. Chizian, the question is, are you going to take an oath or you're going to take an affirmation?
I'll take an oath.
Yes.
Yeah.
Okay, so do you have any sort of a holy book in front of you that you can take an oath upon?
No, I'll take in the name of God.
So he'll take an affirmation.
Yes, so it's an affirmation.
Affirmation.
Okay,
Yeah.
yes. So can you please repeat after me? I solemnly declare and affirm
I solemnly declare and affirm
that the evidence I shall give
that the evidence I shall give
will be the truth, the whole truth,
will be the truth, the whole truth,
and nothing but the truth.
and nothing but the truth.
Thank you.
Thank you very much. Yes, Mr. Vijani.
Deeply obliged, Your Lordships. Mr. Tizian, could you state your name for the records and your address?
I am N. Cherian, 3/105, KK Salai,
Mr.
Santoshpuram.
Tizian, may I request you to go a little slower so that it can be transcribed properly? Just go very slow.
I am N. Cherian, residing at 3/105, KK Salai, Santoshpuram, Chennai, India.
What is your qualification and the current position?
I am Bachelor of Science and I am currently posted as Regional Head, Union Bank of India, Chennai South.
You have given your witness statement, which is at pages G202 to G216, 213.
Yes,
Is that correct?
correct. I have given.
It is dated 23rd of December 2021. Is that correct?
Yes.
Do you have a copy of this statement with you?
Yes, I have a copy of this statement.
Do you have the electronic copy of the statement with you or a physical copy of the statement with you?
Physical copy.
Do you have the exhibits you rely on as reference C1 to C14, which are enlisted at G214 of the record?
Yes.
Can you confirm that the copy that is available with you in physical form is not annotated or written upon in any way?
Yes. I confirm that it is a clean copy. No annotations are there.
Could you turn to page G213?
Yes.
Is that your signature?
Yes.
Mr. Tizian, is there anything with regard to your witness statement that you wish to clarify?
Yeah. There is a small clarification. If I can take you to page number.
Mr. Tizian, you'll have to go slow. Mr. Tizian, I humbly request you to go slow.
Yes. If I can take you to page number G209.
Mm-hmm.
Para 21. I-22. I-22, the date on top should read as 14th January 2015. The fact can be verified from the next page, the utilization advice. The amount remains the same. It is a typo.
Oh, sorry, what paragraph are you talking about?
I-22.
Paragraph 22.
I-22.
Paragraph 21 is what he said, and document I think he's referring is I-22. But what my lords is asking you, Mr. Chazen, is which is the verification paragraph that you're talking of?
Para number 21 of page number G209.
Yep.
I-22. The date on top should read as 14th January 2015.
I see. Right.
Is this fact a typographical error?
Yeah, it was a typographical error.
Can this be corroborated with any other statement made by you in the witness statement or a document on record?
If I can refer to the next page, I-23, the date down below is mentioned as 14th January 2015 in the utilization request. And the amount remains the same, 309,000.
Is there any further clarification with regards to your witness statement that you wish to provide?
Nothing.
I have no further questions, Your Lordships.
Thank you very much. Mr. Shaheen, you're going next, presumably.
Yes, Your Lordship. Before I proceed with the cross-examination, I would like to make a submission. I'm really sorry. In between, there was a technical glitch and I got disconnected. So I couldn't listen to what D4 was saying. He just started by saying that there is serious prejudice if the trial has to continue despite the conflict of interest. Then I got disconnected. I couldn't hear the rest of it. But I assume that what he said is the trial cannot continue because there is such serious conflict of interest and severe prejudice will be caused to the parties. The trial will not be fair. I support that view. I had submitted a reply statement to the 9th witness statement submitted by D4 today, and I would humbly request permission for me also on behalf of D2 to submit an application regarding the conflict of interest, asserting that the trial cannot be continued. There is no, in my humble view, there's no point giving a ruling on this in the judgment. Either way, it's going to hurt us.
Well, I've given my provisional decision. Did you hear that me when I gave my provisional decision?
That was, I heard it will be in the judgment.
No, what I went on to say was that my provisional decision was that whatever the merits of the complaints about conflict of interest to date, it did not seem to me that it was likely to influence the conduct of the trial going forward. But therefore, I would allow the trial to continue, but that if any matters arose during the course of the trial which caused me to change my view, I would keep an open mind about it.
Is it possible for me to submit an application on behalf of D2?
You can submit an application at any time during the course of the trial, and you can make submissions about it in your final submissions as well. But that, for the present purposes, I will continue with the trial And you must, of course, make any notes you want and bring to my attention at the proper time any instance where you say that there has been prejudice because of the conflict of interest of the claimant's solicitors.
Yes, Your Lordship. Much
That is my
obliged.
present decision. But I should say I received your further submissions. I have not had an opportunity of looking at them carefully, but I will take them into account at the end of the trial.
And Your Honor, if I may just reconfirm that my objections and my concerns have been duly noted on record.
On the duly noted
of the trial, without really deciding on the conflict, I requested that it will be prejudicial.
Yes,
I'm not a lawyer, so I just want to understand whether that has been noted on record.
it will be. It will be recorded as part of the. I will draft an order which the registry will issue, giving effect to what I've just indicated orally, and that will be noted. But it will, of course, be open to you to identify any points in the course of your final submissions to me. Identify any points where you say that, contrary to my present view, there has been prejudice in the conduct of the hearing. All right. Thank you. That is my ruling. For better
Yes,
or
Your
for
Lordship. I heard that view. I beg to differ because the prejudice cannot be pinpointed. That's something presumed in law.
Mr. Shaheen, I understand you differ, but judging is not a negotiating position. I've made a decision, and right or wrong, that is my decision. But I've left it open to be reconsidered at the end in the light of what happens during the course of the trial. That's it.
Okay.
Now, do you want to cross-examine?
Okay. So can I continue with the cross-examination?
Yes, of course. Yes, of course.
Mr. Cherian, how are you?
I'm good, sir.
Where are you now?
I am in Chennai,
You are in Chennai, in India.
India. Yeah.
Have you taken a special permission from any of the competent authorities in India to give your testimony in this case today?
No.
No. You said that you are a representative of Union Bank of India, DIFC branch. Any proof of authority? Any supporting document produced before this honorable court?
No.
No.
Lordships, I'd like to object to this position because this documentary statements, evidences are not required. He's made a statement on oath of what he is.
With all due respect,
Indeed.
it's my turn to cross-examine, and
Indeed.
my learned friend need not interfere. I asked a question, yes or no answer.
Mr. Shaheen, I am dealing with this. I was about to say to Mr. Vajani that yes, he's made a statement on oath. He's being cross-examined on it, and it is perfectly proper for Mr. Shaheen to ask questions about it.
Very well, Lordship.
Because such interference will cause serious prejudice to me again. So please. Now, you are a Bachelor of Science, you said. You don't have any qualifications in finance or management.
I am a qualified associate of Indian Institute of Bankers.
You are a qualified associate of Indian Institute of Bankers, but you have not made any such statement in your witness statement.
Yeah, not mentioned.
You were with the DIFC branch from 2013 to 2016.
Yeah.
And then from 2018 to 2021.
I was at Mumbai. I was posted in the posted as Deputy General Manager in International Banking, overseeing the operations of overseas branches, including Dubai.
Okay. You said you were instrumental at the, I'm referring to paragraph number 10. Hope you have your witness statement.
Yeah.
G205.
Yeah. Yeah.
So you said you were involved and you were instrumental at an earlier stage, and you are in a position to describe the commercial business aspects of the case. Therefore, I'm asking you, at the time of granting the facility for the first time in 2014, the commercial and business aspects of D1 were excellent.
Yeah. It
Yes.
was a newly established company.
Yes. But the commercial and business aspects were very good.
Yeah. The business proposition was good.
So it was your duty to ensure that certain requirement that must be met before the borrower is entitled to borrow or complied with.
Yeah.
Yes. You participated in the preparation of the 2014 sanction letter, the facility agreement, and the guarantee documents.
Yes.
Yes. May I ask you, when there is a sanction letter, what is the requirement of a facility agreement?
Sanction letter is an intimation to the borrower explaining the terms of sanction, nature of facility, amount, currency, tenor, all those things. And the facility agreement is a document. It is a security document which encompasses all these things. In addition to that, jurisdiction, all those things are defined in that.
So facility agreement, as the term denotes, is the document which is signed between the parties, the lender and the borrower.
Yes.
I'm going to G206 now. Paragraph number 13. You're talking about the comprehensive background check, which was conducted prior to granting the facilities.
Yes.
On the 4th, 5th, and 7th defendants.
Yes.
Do you continue to do such checks periodically?
Yes, at least on an annual basis.
At least on an annual basis. When was the last checking done?
I was there till 2016.
2016, that was the latest one?
2014 to 2013 to 16, I was there. Every year, at least the fresh documents like trade licenses are taken, and a continuing due diligence was there.
No, this is due diligence on the first defendant, not only the first defendant, the 4th, 5th, and 7th defendant who were the promoters of the first defendant. That's my question. So when was the last background checking done on the 4th, 5th, and 7th defendants? They are the personal guarantors.
Yeah, I remember that it was done in 2015. Thereafter,
2015, 7 years back.
During my tenure, subsequently, my colleagues would have done.
You are not aware of anything done after that?
Yes.
Coming to G207.
Yeah.
According to your findings, the fourth defendant was a banker with over 24 years of experience who held senior management positions with global banks. I'm not reading the whole thing. And that's the explanation given about D4. And he has experience in working in capital markets, wealth management, Emirates Bank, etc. So he had a very serious, thorough financial background, D4.
Yes.
Yes. And you have mentioned the fifth defendant has more than 30 years of experience in integrated supply chain business.
Yes.
So he was more a technical person.
Yes.
Yes. And in paragraph number 15, you are referring to the conditions precedent relating to documentary proof and other issues. And there you are referring to a director's resolution also. Copies of the resolution to the borrowers, directors, and shareholders.
Yes.
NC1, Exhibit C2, H17 to H30. These are the documents referred to.
Yes.
Can you tell me what does the director resolution say about operations of account and signature authority to sign on behalf of D1? To make it easy, I suggest it always required two signatures,
Yes.
joint signatures on behalf of D1, right?
List, yes, list A and list B.
List B, and there are two signatures required at all times.
Yeah.
What will be the consequence if one request, any finance document submitted to the bank or request or application, whatever form, is signed only by one person? What would your bank do?
We would ask for confirmation from the other signatory in the other list.
Okay. And if you don't get it?
It can be by way of telephonic conversation, or in order not to hamper the business. Maybe in rare instances we can go ahead seeking a telephonic confirmation or any sort of confirmation.
So even though the requirement is double signature, you mean that one signature, one telephone call will do? Is that what you mean to say?
Most of the times we stick to the mandate. Whoever is the authorized signatory from both the lists. We ensured during my tenure, we ensured that all those utilization requests carried the signatures of both the authorized signatories from both the lists.
Can you show me anything, even as your internal banking policy, or anything in the relevant law, which allows you to substitute one signature with a telephone call?
In order not to hamper the business practice, I'm not very sure, but that would have been adopted in rare instances.
So you're not sure whether that can be done or not?
During my tenure, it has not happened.
So if it has happened afterwards, you don't know anything about it?
Yeah.
After 2016, if any such practice is followed, which I would call as malpractice, you are not aware of it and you have no comments on it.
Yeah.
Okay. Now, paragraph number 16. On 20 February 2014, Mr. Anupam Mehrotra of the claimant's office issued a sanction letter for US dollar 3.1 million, you have stated. Is Mr. Anupam Mehrotra still available? Do you know his whereabouts?
No, sir. He left the bank.
He left the bank and you don't know his whereabouts?
Yeah.
So he's not being examined as a witness before this honorable court?
Yeah.
And the 2014 sanction letter, you stated that it was signed by the promoters of the first defendant.
Yeah.
So it is the practice of the bank to take the signature of all the promoters of the company whenever a sanction letter is issued.
It can be signed by the authorized signatories mentioned in the resolution of the company.
Good. So sanction letter must be signed by the authorized signatories of the company.
Yeah.
Any sanction letter, if it is not signed by the authorized signatories of the company, it is not valid.
Yeah.
Am I right? Yes. You have referred in paragraph number 17 to a resolution dated 17th March 2014, signed by the promoters of the defendant and sixth defendant, NC1 Exhibit C4. What is this resolution about?
Let me check, sir, just a moment.
I'll make it easy for you. I-73, the document number I-73, Your Lordship. It very clearly says that the D4 and D5 are to sign jointly on any document on behalf of D1.
Yes.
Correct?
Correct.
That's next one, paragraph number 18. On 18th March 2014, when the facility agreement was issued, NC1 Exhibit C5, the facility agreement was signed as accepted by fourth through on behalf of the first defendant, and then also by fourth through seventh defendants as personal guarantors. Am I right?
Correct.
So that is also a mandatory requirement. When a facility agreement is issued, the signatures of all the stakeholders are obtained on behalf of the company and from the guarantors.
On behalf
That is the practice of the bank.
On behalf of the company, authorized signatories can sign.
Yes, and then the personal guarantor signatures were also obtained in 2014.
Yeah.
Yes. Paragraph number 19. On the same day, the defendant executed an account pledge agreement, which is NC1 Exhibit C6, which is a pledge of the bank account. Am I right?
Yes.
Did you have any other pledge?
Asset pledge was also stipulated.
Asset pledge was also stipulated. Asset pledge means the plant and machinery of D1.
Yes.
Yes. When was the asset pledge agreement executed?
It was mentioned as a condition subsequent in the facility agreement. And it was executed in 2015.
In 2015, you got an asset pledge agreement executed, whereby the plant, machinery, everything belonging to D1 were pledged in favor of the bank.
Yes.
Yes. You are also talking about an assignment agreement. in the same paragraph.
Yes. Yes.
What is this assignment agreement about?
Assignment of receivables.
Assignment of receivables. You have not produced it before this honorable court. I don't see any reference number there. Have you?
It is there in the facts, sir.
It is there.
Yeah.
Did you sign any other assignment contracts with D1 other than the assignment of receivables?
Assignment of lease.
Assignment of leasehold rights or assignment of lease was signed. When was this signed?
In 2015. It was
In
as a condition
2015 itself. So these were the real tangible securities the bank had. Assignment of leasehold rights, pledge over assets, and pledge over the bank account, and fourth one, assignment of receivables. 4 documents were the real tangible security the bank had for the facilities granted.
Yes.
You can add if there was anything more.
Only these are the documents taken.
Only these 4.
Apart
Others
from
were
the guarantee.
just corporate guarantees and personal guarantees, nothing else.
Yeah.
Will you
So
deny,
Mr. Shaheen, sorry, just for my note, I've got down assignment of leasehold rights, assignment of receivables, the asset pledge. What was the fourth?
2 separate documents, Your Lordship. One is the pledge over assets, which is the plant and machinery. Then there is an assignment of leasehold rights.
Yes.
Then there is
So
a pledge over the account, the bank account itself.
Yeah.
Then there is an assignment of receivables, 4 tangible securities the bank had.
Okay, thank you. Yeah.
Thank you. Will you deny it if I say that the bank had a duty to protect its security?
Yes. I will
The
not
bank had a
Bank had
duty to protect its
Yeah.
security.
Yeah.
When you sign an assignment of leasehold rights, is it a contingent agreement or an agreement with an immediate effect? How does it operate?
It is a contingent agreement.
It's a contingent agreement. What is the contingency that is contemplated there?
The borrower will make periodic lease payments to the lessor.
Yes. That's not a contingency, that's a condition. What is the contingency on which this security get enforceable? The security becomes enforceable.
If the lease rent is not paid.
If the lease amount is not paid, that is the contingency on which the assignment of lease as a security becomes enforceable.
Yes.
Yes. Meaning the bank as the assignee, the beneficiary of the assignment of lease, will step into the shoes of the lessee, which is the borrower, and exercise the rights and fulfill the duties of the lessee.
Yes.
Yes. Are you aware of that contingency happening, that the lease amount not being paid?
Not during my tenure.
Not during your tenure. So you don't know whether such a contingency happened or not.
I was aware.
You were aware.
Yeah.
When was that?
If I remember right, must be 2019 or 20.
2019 or 20, that contingency which gives the bank the right to enforce the security. That is, the borrower's failure to pay the lease amount happened.
Yeah.
Were you informed by the borrower, D1?
I'm not sure, sir.
You are not sure. If I say D5, which is Mr. Ravi Kuchimanchi, acting on behalf of D1, approached your bank and requested you to exercise your rights under the assignment of lease and protect the security, what would be your response?
Yeah.
It happened.
Yes.
Yes. The bank, what step did the bank take?
I was not aware of the communication that transpired between Ravi and the DAFC branch because I was not there at that time.
So you are not aware whether the bank took any action or not.
Yeah.
If you were the manager of the bank and during your tenure, such a contingency had happened, what you would do as a banking practice?
I try to make the lease payment from out of maybe the deposits in the accounts for which I had pledged.
You would have tried to make the lease payment from the money available in the borrower's account or other sources and protect the lease.
Yeah.
Okay. And just a general question again, I'll go to the specific ones. Suppose there are serious defaults from the borrower. Will you enhance the facility? Will you renew the facility?
Yes. Renewal is being undertaken on an annual basis, depending upon the conditions of the borrower.
Renewal of the facility is happening on an annual basis, depending on the conditions of the borrower. What about enhancement of the facility?
The enhancement, depending upon the financial position, sales projections, and other documents, the bank can take a call.
Okay. So my direct question is, if there are serious default, will the bank still enhance the facility? Normal practice.
Normal practice, banks don't do, but depending upon the new ventures or some other sales expectations, sales projections, banks can reasonably undertake enhancements.
Okay, I don't want to add anything more to that. Your answer remains. Now coming to paragraph 20. You're referring to sanction letter for in the second line, paragraph 20, you're referring to first line, it continues. The facility was enhanced and renewed by a sanction letter for the years 2015 to 2019. The sanction letter was for 4 years.
No.
That's how it is stated. So which is correct? What you stated in your witness statement or what you're saying now?
What I'm saying is correct.
What you're saying is correct. Please go ahead, clarify that. Because I'm seeing sanction letter for the years 2015 to 2019 in your witness statement. I have not seen a document like that. Nothing has been produced before the Honorable Court. That's why I'm asking the question.
Periodical review and renewals have been undertaken every year. Normally, every year we'll collect the financial and other documents and the sales projections from the borrower for undertaking the review.
So there is nothing like one sanction letter for the years 2015 to 2019.
Yes.
What do you mean? Yes, there is no document like that, right?
Yes, there is no document. Continuously
no-
for 4 years.
And amended facility agreement for 2016 and 2017. Is there one amended facility agreement for 2 years?
No.
No. You are saying that the claim relates to a dispute arising under the 25th November 2017 facility agreement. 25th
Yes.
November 2017 facility agreement is the basis for this claim. This is
Yes.
what you have stated.
Yes.
What was the effective date of this facility agreement?
25th November 2017.
That's the date on which you signed. I'm asking what was the effective date? Will you deny it if I suggest that was 18th June 2017? 12th June 2017.
Yes.
It's correct.
It takes effect from 25th November 2017.
What if the facility agreement states that it takes effect from 12th June 2017?
The 12th June 2017 you are referring to is a sanction advice.
No, the facility agreement says the effective date is 12th June 2017. You can deny it.
No, I don't remember seeing.
And 2.4 of that facility agreement, amended facility agreement that was signed on 25 November 2017, clause 2.4 says that that facility will expire on 12th June 2018. Which is a document number.
Can I ask for the document?
Sure. Please refer.
What is the
My
reference
friend,
number,
Mr.
please?
Tajani, if you want to help, you can show him the document. You can help him to look at the document. It is H336.
Correct. 332.
H332 is a sanction letter. H332 is a sanction letter.
No, 336.
Shahid, you wanted to see the 25th November document, right? 8336.
It is dated 25 November 2017. I'm referring to clause 2.4.
Begins at 8334, Mr. Kevin, and my learned friend wants you to see the page H336.
I think the number I made a mistake. It's H347. 347. I'm sorry. What is this one? 2.4.
You want him to go straight to clause 2.4, is it?
It is 2.4.
Yes. It doesn't say it is available up to June 2018, class 2.4.
Yes. As per 2.4, the facility is available up to June 2018. So, on or before that date in June 2018, if the facility is not renewed, the borrower is obliged to repay the money to the bank.
In banking practice, the renewal is undertaken depending upon the submission of financial and other documents by the borrower.
Yes. If no renewal is happening, the borrower has to repay the money because the bank has to collect his money back, right?
That will hamper the regular operations of the business.
Not clear. I don't understand.
That will hamper the, all on a sudden, if you put a stop, that will hamper the business operations of the borrower.
So you mean to say that even if a facility is not renewed, you will allow your customer to enjoy the facility and continue?
Yes, up to the limits available.
Up to the limits available. You are contradicting clause 2.4 of the facility agreement. What do you have to say about that?
This facility agreement is drawn after the annual review. Depending upon the enhancement, there may be an amended facility agreement.
Sanction letter, that is current H329.
Yes.
The first paragraph in that page number 2 of which page number is this? This is H329. The facility will be due for renewal on or before 30/5/2018.
Yes.
And rest whatever is stated there is there. Now, going back to 21, paragraph number 21, where you had a clarification. You said the facility agreement dated 14th January 2014, as per the correction.
Facility agreement is dated 18th March 2014.
But you corrected it.
That was a utilization request. The date of the utilization request was corrected.
The utilization request was before the facility agreement, you mean?
Export package.
No, it was a typo.
Maybe.
You can clarify whatever you want to say. It's not clear to me.
It was a typo. The company intended the date to be 14th January 2015. Instead, they mentioned the date as 14th January 2014.
Okay. And is this the date of the facility agreement or the utilization request?
This is the date of the particular utilization request.
This is the date of the utilization request. How were the utilization requests signed at that time? Who signed?
Normally, Ravi and Vijay.
Normally, Ravi and Vijay means D4 and D5.
Yeah.
What if it was signed only by D4? Will you pass or will you stop?
Such a circumstance did not come up during my tenure.
During your time, it did not come up. If it had come up, it's a hypothetical question. You can answer yes or no. Or you can refuse to answer.
I would call up as an alternative in order to, in the interest of continuing the business operations, I would adopt some alternate method to get in touch with the other signatory and go ahead with the transaction if it is absolutely essential.
If it is approved by the other signatory, then you will go ahead with the transaction.
Yeah.
Yes. General question. What do you mean by digital signature?
By means of a pen drive, it is specifically given by a government agency, digital signature.
Specifically given by?
Here in India, it is given by a government agency, digital signature.
Government agency. There is no such practice of digital signature for private companies or individuals.
Private companies can also take digital signature from the government of India.
Is
They
it
can
in the
affix
form
the
of a
digital
secret code? Sorry, please continue.
They can apply to government of India for obtaining a digital signature. Normally, they are given a pen drive sort of thing for affixing the digital signatures.
Okay. Does it go by a secret code, a pin generated by this pen drive?
Yes.
Yes. Digital signature doesn't mean a electronically copy pasted signature.
Yes.
Paragraph 24. Fourth defendant from list A and the fifth defendant from list B signed the utilization request in NC1 exhibits C8 to C12 pertains to the period 2014 to 2015. Were they original signatures?
Yes.
Yes. Have you produced the original document before this honorable court?
Documents have been produced.
Original documents have been produced.
Scan copies are provided in the book.
Scan copy is not an original. I'm asking you, have you produced the original document before this honorable court?
I'm not sure.
You are not sure. Are you aware that D5 had challenged the signatures as electronically copied, forged signatures? Are you aware of it?
It hasn't happened in my tenure.
Are you aware that now he is challenging in this case that it was not his signature, it is electronically copy pasted? Are you aware of that?
Yes.
Yes. Despite that, you did not bother to produce the original before the honorable court and prove your case. Am I right?
Yeah.
Yes. Now coming to paragraph number 25. First, I'll ask you a general question. In a current account, when does the amount become due for payment? You said you have banking qualification, so you can help us. In a current account, when does the amount become due for payment?
Current account, normally the borrower or the customer has a credit balance available. So it doesn't become due.
It doesn't become due. Whenever there is a credit or debit balance available, it is not due for payment. When does it become due for payment?
Whenever there is a debit balance in the account.
Your understanding is that whenever there is a debit balance in the account, it is immediately due for payment.
If there are sanction limits, depending upon the tenor of the tenor allowed. So
that's under the facility agreement. That's under the facility agreement. I agree with you. The limit is there. It cannot cross. There are conditions. But I'm talking generally about a current account. I will refer specifically Article 402 of the UAE Commercial Transaction Law, law number 18 of 1993, says that only the amount at the closing of the account will be an amount due for payment. Are you aware of it?
Yeah.
You are aware of it. What is the status of the current account in the name of the borrower? Currently, is it closed?
No.
No. So I say your claim is premature because you have filed the case without closing the current account.
No. It is
You don't
not
agree?
necessary. I don't agree.
You don't agree. Now, paragraph 25. Event of default occurred when the first defendant failed to make payments and their account has been classified as non-performing account on its book on 31st August 2019. Were you in DIFC branch overseeing this account at that time?
No.
No. So you don't have any direct knowledge about it.
I was overseeing the operations in Mumbai.
You were overseeing the operations in Mumbai. So what were the events of default that occurred?
Beyond the due date, 90 days would have crossed. That is one of the financial defaults.
That's your assumption. Would have crossed.
No, it happened. From the drawdown, I think the drawdown happened in December 2018 with a usance period of say 120 days allowed. So it becomes due in April 2019. After that, after the expiry of 90 days, it becomes NPA.
Did you issue any recall notice? Are you aware of it?
Yes, it was issued on 3rd of September.
3rd of September, which year?
2019.
2019.
Mr. Shaheen, can you stop for a second? My phone. Sorry about that.
Continuing with this. So 3rd September 2019, a recall notice was issued. That's what you said just now. Does it specifically say the events of default?
Yeah.
Yes. Can you please show me document number?
It's not there in my witness statement.
It is there in your witness statement. Paragraph number 27. I confirm that on 3rd September 2019, the claimant served the first defendant with a demand notice. I-3223. I-3223.
Yeah.
What are the events of default described there? Tell me only what is written there.
Overdues not paid.
That's only default.
Yes.
Yes. Are you aware of the Supreme Court guidelines in UAE in calculating interest?
No, I am not aware.
You're not aware. What if I say charging of compound interest is completely illegal in UAE according to the Supreme Court guidelines?
DIFC is a branch of Union Bank of India. It follows RBI guidelines.
So you're not bound by the UAE Supreme Court.
No, I'm not saying.
Have you charged compound interest in this case?
Normally, the borrower is expected to pay on the interest payment date.
That everyone knows. Suppose he doesn't pay interest on the due date. Do you charge interest on interest? That's the question about compound interest.
We charge penal interest 2%.
That's a separate question. Did you charge interest on interest?
No.
Are you sure?
Yeah, because the interest is applied on the due date only.
Okay. Have you taken an expert report in compliance with the Supreme Court guidelines about charging of interest in this case?
No.
Do you know that any judgment, if it includes compound interest, will not be enforceable in UAE?
I'm not aware.
You are not aware. Paragraph number 28. I confirm that the bulk of the loan remains outstanding. I say this statement is incorrect. What do you say?
It is correct.
The loan amount, the total amount was 10.4 million.
Yeah.
The total amount you are claiming, including penal interest, is in the range of 2.4 million.
This is with regard to there was a mention by one of the promoters that the limit will not be availed beyond a certain limit, self-controlled limit.
Which promoter did say that?
Vijay?
That means D4.
Yeah.
So were you operating the account based on the facility agreement signed by the parties or at the instruction of D4?
Governed by facility agreement.
Facility agreement says 10.4 million.
They are the authorized signatories of the borrower.
Authorized signatories, they are two, not one. Okay. Paragraph number 29. As a result of the non-payment, I confirm that the claimant has suffered losses in the sum of 2,288,367 cents 42. So are you claiming your losses or are you claiming repayment of the amount granted as loan?
Repayment of the amount.
But here you are stated you have suffered losses to the tune of this amount. Do you have anything to say?
It's a repayment amount that is due from the borrower.
So what you stated in the witness statement is wrong.
The bank needs to keep provision for this.
That's not the question I asked. Okay, we can stop it there. Now, you said you had legal costs of $47,000. Have you submitted any proof?
No.
Have you submitted any proof to show your losses? I'm not talking about repayment of the money. I'm asking you for your losses. Have you produced any evidence?
No.
No. I'm done, Your Lordship.
Thank you. I'm concerned, if I can just address all parties. I haven't interrupted because it was important to see how we're going in practice. But according to the timetable, that cross-examination should have lasted 30 minutes. It's lasted nearly 60. I'm not saying it's irrelevant. It's perfectly legitimate, but it means that, in my view, it suggests that the timetable estimate is completely in fairyland. It has no resemblance to what is going to happen in this case. So we're going to stop for 10 minutes. But in the meantime, can parties just talk to each other about whether realistically we're going to be able to meet the timetable or anything like it. All right. Don't apologize because it's important the proper questions are put. But if the time is not available, then we've got to make time available. And if necessary, we'll have to have an extra day or two. But I just wanted to let that run because
they have to party responsible has to pay for it.
We'll deal with that in due course. We adjourn for 10 minutes. So we'll resume at 9:25. And Mr. Chezian, would you not talk to anyone about your evidence in the meantime, please?
Yeah.
We're going to stop for 10 minutes.
Yeah.
Okay?
Your Lordship,
Thank you.
Can he rise to take a short break and a short walk in the office?
Yes, provided that you don't talk to anyone about the case.
Mr. Chezian, please don't talk to or interact with anyone. You can go round the corner and be back on your seat immediately.
I'll not.
Drink water.
Thank you. Thank you, Your Lordship.
Right, well, is everyone here? What I suggest we'll finish this witness and take stock of time and then have a discussion after this witness is finished. It's important that people don't feel they can't ask the relevant questions, but it just means we have to reassess how realistic the present timescale is. But we'll come back to this after this witness is finished. Yes. Yes. Mr. Kapoor, I think it's your turn to cross-examine.
Yes, just a question, Your Honor. In case nobody else has any objection, I would like to request if I can ask my questions after counsel's for 6 to 8 cross-examine the witness.
Ms. McLean?
My lord, I'm content with that.
You're content with that? Very well.
I am.
Thank you so much. We just needed a couple of minutes because there was a technical glitch here and I need to print a document, please. Thank you.
Okay, just give me a couple of minutes to print a document.
But would you, in the meantime, is 6 to 8 going to cross-examine or you're waiting for me to print?
No, I'll wait for you to print. If you'd like to print the document now before we start.
Yeah, all right, thanks. Just give me 2 minutes, please.
Yes, please. You done?
Yes, please.
Right. Well, we'll have Ms. McGlone first then. Yes, Ms. McGlone.
Thank you, my lord. Mr. Chazian, good afternoon.
Good afternoon.
Can I just check a couple of things before we begin? First of all, how is it that you pronounce your name? Is it Mr. Chazian?
Yeah.
Thank you. And secondly, do you have a copy of the trial bundle available to you?
Yeah.
You have the trial bundle?
Yeah.
Thank you for confirming that. Now, Mr. Chazian, you explain in your witness statement that you were CFO through the DIFC branch of UBI from February 2013 until May 2016. That's correct, isn't it?
Yeah.
And during that time, you were authorized by the DFSA?
Yeah.
And you understand that that meant that you had to observe high standards of integrity and fair dealing, don't you?
Yes.
And it also meant that you had to act with due skill, care and diligence in carrying out your functions.
Yes.
Mr. Chazian, you also explained in your witness statement that between 2016 and 2018, you worked for a number of UBI's Indian branch offices, didn't you?
Yes.
And then from 2018 to 2021, you oversaw the Dubai branch, but you oversaw it from India. Is that right?
Yes.
At paragraph 10 of your statement, which is at G205, which is the fourth line of that paragraph, you say, I was involved and instrumental at an earlier stage. So by that, you mean that earlier stage pre-2016, rather than in the matters concerning the 2017 agreement. That's correct, isn't it?
No, I was not involved in 2017 agreement.
Yes. And so you can't speak to any of the events around the 2017 agreement, can you?
Yeah.
Now, at paragraph 12 of your statement, you explain that D1 approached UBI on the 2nd of January 2014. Can I ask you to go to I-20 in the bundle, please?
Yes.
Yeah. You can see that this is a letter from D1. Velocity is the header on the letter, isn't it?
Yes.
And it's a letter requesting credit facilities. It's,
yes.
You can see that, yes. It's dated the 2nd of January 2014.
Yes.
And then if we just go over the page to I-21.
Yes.
It's signed by, well, it is D5 and by D7. That's correct,
yes.
isn't it? And are you aware that at that time, those two individuals were the only directors and authorized signatories of the company? At that time, in January 2014?
No.
You're
no.
not? Perhaps then I could ask you to turn to Mr. Gupta's fifth statement at G284.
Yeah.
Got that? And he refers to paragraph 12 of your statement. And
What paragraph?
sorry, paragraph 9. Do apologise, my lord. paragraph 9 on page G284.
Yep.
Now, Mr. Gupta refers, as I say, to paragraph 12 of your statement, Mr. Chezian. And then if we just go over the page to paragraph 10 on page G285. You there?
Let me check. Just a second. Yeah, 285.
Yes, 285. And about halfway down paragraph 10, Mr. Gupta states, the reason why the letter has been signed by me and Mr. Kuchimanchi is because at that time, we were the only two directors and authorised signatories of VIL. Do you see that, Mr. Chezian?
You are referring to which class?
Sorry, Mr. Chezian.
You are referring to which? You are referring to which class, please? Which para number?
10.
10. Yeah.
Of Mr. Gupta's statement, 5th line down, the sentence beginning at the end of that line, the reason. Do you see that, Mr. Chezian?
Yeah.
And that explains that at this time, 2nd of January 2014, Mr. Gupta and Mr. Kuchimanchi were the only two directors and therefore the only two authorised signatories of VIL.
I'm not getting, please.
Mr. Gupta explains at paragraph 10 of his witness statement that in January 2014, he and Mr. Kuchimanchi were the only two directors of VIL. Do you understand that?
Yeah.
Right. And then if we go back to I-21 in the bundle, the letter that we were looking at a short while ago,
Yeah.
yes? And you see
Yeah.
there that it's D5 and D7 signatures.
Yeah.
And that's the reason which we've just covered. So we have a request here for credit facilities in writing, signed by the company's directors. And this is standard practice. When an entity or an individual is seeking to use a bank's services, you would expect to see some sort of request in writing, wouldn't you?
Yeah.
And in fact, when an entity or an individual has anything particularly important which they need to communicate to a bank, you would expect to see it in writing, either as a letter or email or in a note of a telephone call. Yes?
Yeah. Any form of communication, letter, email.
Now, at paragraph 15 of your statement, you explain the process which UBI followed in 2014 before it granted the facility, or the first facility, I should say. Now, you refer to the document which is at H17 to 30.
So what paragraph of the statement are you on?
Paragraph 15, my lord.
Thank you.
Yes. So this is the sanction letter of the 20th of February 2014, isn't it?
Yes.
And you also explain in your statement that UBI's team checked that there were copies of resolutions by the company's directors and shareholders, and that there were guarantees and security in support of the company's borrowing, don't you?
Yeah.
And UBI's team would have reviewed those documents to check their contents, wouldn't it?
Yep.
This is a thorough process, isn't it?
I'm not getting.
It's a thorough process.
Yeah.
And it's important, in fact, that any bank goes through these processes before it lends money. Yes.
Yes.
And in fact, we see that level of care when it comes to the 2014 lending by UBI to Velocity, to D1. I took you a short moment ago to the 2014 sanction letter at H17. Now, Mr. Chezian, when you were being asked questions by Mr. Shaheen, you stated that a sanction letter is an intimation to a borrower. So
Yes.
yes, so it's a precursor to a facility agreement, isn't it?
Yeah.
And then the facility agreement itself in 2014, you refer to that at paragraph 18 of your statement, don't you?
Yeah.
Can we go to that facility agreement? It's at H31.
Do you mean that?
For 2014, my lord, yes.
Oh, yes. Yeah. Okay.
Yeah.
And we can see on that covering page that it's stated to be a facilities agreement for just over $3 million, can't we?
Yeah.
Yes. And then if I can get you to go to H33.
Yeah.
And towards the bottom of that page, you'll see that there are various terms provided with explanations of what they mean. And the second from bottom on that page is availability period. Do you see that?
Yes. Mm.
Yes.
Yes.
And it states that it's the period commencing on the signing date of this agreement and terminating on the final maturity date, unless otherwise extended at the sole discretion of the lender.
Yes.
And then if you go to H35, so 2 pages on.
Yes.
And the third definition from the top, final maturity date, means the date falling 12 months from the date of this agreement, except where such date is extended at the sole discretion of the lender.
Yes.
So there's no obligation on the lender to extend, is there?
There are two types of facilities here. The term loan, normally the tenor extends for a longer period. That is the end date for the term loan facility. As far as the working capital is concerned, it is reviewed every year.
Yes, Mr. Chezian, that wasn't my question. My question is, where it states in this agreement that certain periods can only be extended at the sole discretion of the lender, that doesn't impose an obligation on the lender to extend, does it?
Yes.
Yes, the lender doesn't have to extend.
Yes.
It's got a discretion.
Yeah.
And if we go to H40, please.
Yes.
40, yes. If you see clause 2.1 on that page, that just explains that the facilities will be made available to the borrower during the availability period.
Yes.
And we just had a look at what that means. Over the page, H41.
Yes.
Clause 3.2 states that the lender shall be under no obligation to make any advance or to open or issue any letter of credit if it's got various criteria. And the second one, under subparagraph B, is a default has occurred and is continuing or would occur as a result of such utilization. You see that, don't you?
Yeah.
Now, I'm not going to ask you to go back in this agreement, but you can take it from me that a default is defined as an event of default or a potential event of default. And just for your lordship's note, and that definition is in H34. Now, in terms of what an event of default is, this is explained at H60.
Yeah.
We see there 18.1, each of the following shall constitute an event of default. Subparagraph A refers to non-payment. And then there are various other events which can constitute an event of default. But if we go over the page onto H61, we see that clause N, or subparagraph N, refers to changes in ownership. You see that, Mr. Chesian?
Yeah.
And subparagraph P refers to litigation. Yes?
Yeah.
Then if we go to H62,
Yes.
clause 19.1a requires the borrower to maintain cash collateral equal to 25% of the facility amount in what's to be known as a cash collateral account. You see that?
Yeah.
And then if we go through to the end of this agreement at H70,
Yes.
we see that the agreement has been signed by D4 and D5 as directors of D1, yes?
Yes.
And of course, it's been signed by UBI. And then on H71, we see that it's been signed by various of the personal guarantors.
Yes.
And then, as you explained earlier, Mr. Chesian, there were various other documents which supported this facility agreement in 2014. And the next one I'd like you to go to is the account pledge agreement, which starts at H75.
Yes.
Right. Now, I'm not going to take you through the entirety of this agreement, you'll be pleased to hear. But if we can go to H77, please.
Yes.
And we see there account means the account number, and then there's an account number which is set out there. Now perhaps you could help me. Is that the cash collateral account?
Yes.
It is. And is a current account, or is the current account in this case the same as the cash collateral account?
No.
it's not, the current account would be something different, would it?
Yes. This is a current account which has a facility beyond a certain amount, it will be swept to the deposit account.
Right. So
there will be a threshold amount of say $10,000. If there is a balance of $50,000, it will be swept as deposit. $40,000 will be swept as deposits.
right, but the current account you're saying is different from the cash collateral account.
Yes.
Another agreement which was executed at the same time as this one is the assignment agreement, sorry, for receivables. I'm not going to ask you to pull that up because it was previously flagged to you by Mr. Shaheen. But again, for your Lordship's note, that begins at H91. And in addition, Mr. Chezian, you also noted earlier that in 2014, there was also an assignment of the company's leasehold and an asset pledge. That's correct, isn't it?
Yeah.
Now, in addition, there were declarations and a resolution provided by the company at this time, weren't there?
Yes.
And the declarations are at pages I-70 to I-72 of the bundle. Yes.
Which document you are referring to? Which document you are referring to, please?
The document at I-70, it's dated the 12th of March 2014. And the heading is General Declarations and Undertakings. You have that?
No.
You don't. At I-70 bundle.
Yeah.
You do. And you can see that that's signed at the bottom by D4 and D5. Yes?
Yeah.
And then if you turn to I-73, this is a document headed Director's Resolution.
Yes.
And it's dated the 17th of March 2014. And it's in relation to the company obtaining the facility from UBI. And then at I-74, which is just on the next page,
yes,
we can see there that it's signed by all 4 directors of D1, isn't it? Yes. So we've got a comprehensive set of documents in order for D1 to obtain lending from UBI, don't we?
Yes.
And that's not surprising, is it?
Yeah.
Because it's important that banks adopt a thorough approach when they're providing lending, especially in the sorts of sums we're looking at here, isn't it?
Yes.
Mr. Chezian, you were asked earlier about paragraph 20 of your statement and about the 2017 agreement. But as you say in your statement, and as you said earlier, you actually weren't working in the DIFC branch of UBI between 2016 and 2018. So I'm not going to ask you about the 2017 agreement. And in fact, your comments at paragraph 20 of your statement they're not actually based on your own direct experience of any events between 2016 and 2018, are they?
Yes.
Now,
When you say yes, you mean you agree?
Yeah, I agree.
Thank you.
I'm grateful, my lord. Now, Mr. Chesian, you agreed a moment ago that the bank adopted a thorough approach, or sought to adopt a thorough approach in relation to its lending. And we can see that thorough approach in some of the due diligence which was carried out by the bank. Paragraph 24 of your statement, you refer to payments which were made, or payments being made, by the bank to D1's suppliers from 2014 through to 2019.
May I ask which para you are referring to?
Paragraph 24 of your statement at G210.
Yeah.
Just in the third line of that, yes. Now, we don't have any evidence from the bank's risk or compliance department, so I'm going to ask you some questions about its approach to due diligence during that period, because obviously you've been working for the bank for a long time now. Can I ask you, first of all, to go to I1694 in the bundle?
Yeah.
You there?
Yes.
Give me a second.
Sorry, Ms. McLuhan, can you repeat the page? I missed that.
Of course, of course. I1694.
Thank you.
My lord, can I ask if you've managed to reach that page?
Nearly. Sorry.
No, that's quite all right.
Yeah. Got it.
I'm grateful, my lord. Now, Mr. Chesian, we can see that this is a document dated the 2nd of July, 2017.
Yes.
Yes, yes. And it's a request for the payment of $20,000 to Emirates Polystyrene Industries, isn't it?
Yes.
Now, for your lordship's information, this is one of the companies to whom payments were made relatively frequently during the relevant period. Now, if you could go a few pages on, Mr. Chesian, to page I1702.
Yes.
Now, this is the world check results for Emirates Polystyrene, isn't it?
Yes.
Yes. And there appears to be nothing of concern in relation to this company. That's correct, yes?
Yes.
Yes. But it's possible, isn't it, that there might be issues with this company that this sort of search just doesn't pick up. That's possible, isn't it?
This world check is updated, say, 2 lakh times every hour. So it
Of
captures
course.
almost all the events all over the world.
No, I understand that, Mr. Chesian, but for example, it doesn't show whether Emirates Polystyrene is a legitimate company, or that it doesn't show that it provides the type of products which D1 might need, does it?
It doesn't provide.
No, no. Can you go on to page I1705, please?
Yes.
Now, this is, it appears to be a directory result for Emirates Polystyrene. Now, again, it indicates that the company exists, but it doesn't show that it provides the type of products which D1 might need, does it?
It does provide. If you look at the categories down below.
Sure, bottles and plastic products. But it's
Yeah.
interesting because if you can go onto page I1707,
Yeah.
here we have the web page for Emirates Polystyrene. Yes. And so the bank clearly felt that it needed to double check that Emirates Polystyrene was providing the type of product that D1 might need, didn't it?
Yeah. Yes.
And the address on this page, which is in the bottom right-hand corner, matches the address which was on the directory entry, which we just looked at I1705. So we've got the bank checking, in addition to its world check, its world check search, we've got the bank checking that this is a legitimate company, that it's likely to be a supplier to D1. And that's what you would expect, isn't it?
Yep.
Now, can I ask you to go, please, to I156?
Yeah.
My lord, can I ask if your lordship is there as well?
Sorry, I was making another note. I156.
Yes, my lord.
Yeah.
And Mr. Chezian, you there? Mr. Chezian, this is a document from the 25th of May 2015.
Yes.
Again, it's a payment request from D1. And this time, it's a request.
Sorry, I must have the wrong document. What page did you say? I156.
Yes, my lord.
Oh, sorry. Yeah, okay. Give me a second.
Of course.
I was treating the I as a 1. No.
Your lordship won't be surprised to hear that your lordship is not the only one who finds that confusing on occasion.
Okay. The payment request, 25th May.
Yes. Mr. Chezian, it's a request for a payment of around 73,000 US dollars to be made to Launchpad General Trading, isn't it?
Yes.
I can tell you that this appears to be the first payment request for Launchpad. Now, if we go through the next few pages until we reach I163, you don't need to read any of those pages in detail, but if you just take a note, as it were, as we go through, and let me know once you've reached I163.
What are we taking a note of?
Just sort of a mental note, really, of what each document is, not a detailed note.
Yeah, until 163.
Yeah.
Yes.
Right.
Now, we don't see any world check search results here, do we, Mr. Chezian?
No.
No. We don't see any directory entries for this company either, do we?
No.
And we don't see any web pages relating to this company either, do we?
No, we don't see.
No, we don't. Can we go next, please, to I979?
Yes.
Is your lordship at I-979?
Nearly. Yeah, okay.
Mr. Chezian, this is a document from the 27th of June 2016.
Yes.
It's another payment request for payment to Launchpad General Trading. I should say actually that the request really begins on the previous page at I-978, but the point is really rather the same, which that is a payment request for just over $200,000 to Launchpad, isn't it?
Yes.
Yes. And I can tell you, Mr. Chezian, that in the intervening period between the document we looked at a short while ago from 2015 and this document, a number of requests were made for payments to be made to Launchpad, but they were in much the same form as the one we just looked at. So there was no world check search or anything like that. Now, if you go to page I-986,
Yes.
now we see here that this is a directory result for
Yes.
Launchpad General Trading. The description at the bottom just says that it works in procurement and trading business activities, doesn't it?
Yes. Yeah.
So it indicates that the company exists, but it doesn't really show what types of products it provides that Velocity might need, does it?
Yes.
You agree?
They are into trading business.
It's a trading business, but it doesn't indicate what it trades in, does it?
Yeah.
So we still don't have a full insight into what it is that Launchpad does, do we?
Trading is a general term encompassing various materials.
Precisely, Mr. Chezian. It's a general term. It's a general term. Can I ask you to go to I-1001, please?
Mm-hmm.
Now, again, we have another payment request, this time from the 26th of July 2016 for $177,000. And again, if we could go through or skip over really the details of the request because they're the same as all of the others, and go to I-1009, please. Yes. That's that directory result again, isn't it? Mr. Chezian? At I-1009, it's the same directory result as we've just seen, isn't it?
Yes.
Yes. If you can go over the page to I-1010.
Yes.
Now here we do have the world check search results.
Yes.
And they don't indicate that there are any problems with this company necessarily, but as you agreed a short while ago when we were talking about Emirates Polystyrene, a world check search result isn't necessarily going to give you the full information about a company, is it?
Normally, it doesn't miss. The details are updated very frequently.
Mr. Chezian, we agreed on that before, that it's updated regularly, but as you agreed in relation to Emirates Polystyrene, a world check search isn't going to tell you whether the company is actually a legitimate company which is providing the type of products that D1 might need. You agreed that in relation to Emirates Polystyrene, and that's correct, isn't it?
Yes.
Yes. Now could we go, please, to I1780?
Sorry, 1780.
Yes, my lord.
Right.
This is the last payment request for Launchpad, which I'm going to take you to, Mr. Chezian. But of course, there are many others in the corpus of documents. This is from the 24th of August, 2017. It's a request for $232,000, thereabouts. And again, it's a request for payment to Launchpad. And can I ask you to go to I1788, please? 1788.
Yes.
Now again, we have a world check search result, and that goes on. We have 3 of those. So 1788, 1789, and 1790. And then at 1791, there's a printout of a web page. Do you see that, Mr. Chezian?
Yes.
Right. Now, it's unclear whether this in fact refers to Launchpad, i.e. the company to which payments were being made, because we can see from the description of this company at 1791 that it appears to be involved in some sort of asset management. Do you see that, Mr. Chezian?
Yes.
And can I ask you, please, to just go back a few pages to I1782.
Yes.
And this is the pro forma invoice, reportedly from Launchpad. And we see that there's a column there headed description of goods. Do you see that?
Yes.
And the goods are described as Lupstack and Marlinat.
Yeah.
Yes. Now, knowing what D1's business is and seeing this description of goods, it doesn't appear that a company involved in asset management is going to be involved in supplying these goods, does it?
The license is, it is involved in trading business. It can undertake any trading activity.
Well, Mr. Chezian, the web page that we just looked at I1791 is the result of the bank's own due diligence checks. It's the
Yes.
only web page we've got for Launchpad. So whether it may be the right company, it may not be, but this is a document which the bank used as part of its due diligence. And if you look at that first paragraph, the second sentence, and I'll read it out to you, says our aim is to invest proprietary capital in early career portfolio managers to manage assets across the currency, fixed income, equity index and commodity asset classes and related derivative instruments in global markets. I mean, the company which is on that web page is not going to be selling Lipstack and Marlinat, is it?
Yeah, possible.
Mr. Chezian, I disagree that it's possible that it's going to be. Now, it may be that, in fact, the Launchpad trading, which has that web page, is not the same Launchpad as the company to which the bank was making these payments. But in any event, the bank doesn't seem to have thought, when it came across this web page, that it should be concerned that it was making payments for quasi-medical goods to a company which appeared to be involved in asset management. That doesn't appear to have given it cause for concern, does it, Mr. Chezian?
Yes.
The bank didn't carry out any further due diligence on this company, did it?
Normally, the bank undertakes Google checks, word check, and they take the reports from maybe from the bankers or from the independent agencies like Dun & Bradstreet before undertaking the transactions.
Of course. We don't have that for this company, Mr. Chezian. Are you aware of any further due diligence which the bank carried out in relation to this specific company?
No.
No. And as we've seen from going through those documents and the various different payment requests, the bank adopted a slightly different approach to due diligence for this entity each time, didn't it?
I'll not say so.
So, Mr. Chesney, I didn't quite catch that.
I will not say so.
You wouldn't say so. So, Mr. Chezian, you've seen that when the first payment request was made, there was no due diligence. Then there were subsequent payment requests where we had a directory result and some world check results. Then we had other payment requests where we had world check results, but no directory results. And then we have a request where there's a web page, which appears to be for a company which has got nothing to do with the sort of business which D1 is carrying out. So each time, the bank is adopting a slightly different approach to its due diligence, isn't it? You've seen that in the documents, Mr. Chezian.
The bank undertakes the regular practice of due diligence, that is Google check. From that only we got that page. And normally if it is a shipment, means port check, whether any sanctions are there, then vessel check, country check, all these bank undertakes.
But it didn't do that for this company, did it, Mr. Chezian?
Bank would have done that.
I'm sorry, I didn't catch that. Can you say that again?
Such checks would have been undertaken.
Mr. Chezian, I can tell you that such checks were not undertaken, because if they had been, we would have them in these documents, and we don't. And we're going to be asking the court to find that the bank was inconsistent in its due diligence approach, both in relation to this company and in relation to a number of other companies to which payments were made. Now, just in relation to Launchpad, are you aware that D5 is a shareholder in Launchpad, Mr. Chezian?
No.
No, you weren't aware. And are you aware that Mr. Kapoor, D4, suggests that Launchpad was a company in respect of which D5 was committing fraud on D1. Are you aware of that, Mr. Chezian?
No.
Now, you explained earlier that from 2018 to 2021, you were overseeing the Dubai branch of UBI from India, didn't you?
Yes.
Yes. But your statement doesn't quite explain the circumstances in which UBI provided further funding to D1 in 2018, does it? Can I ask you, please, to go to I2975?
Yes.
Give me a second. Yeah.
This is an internal memorandum dated the 15th of November 2018.
Yes.
Isn't it, Mr. Chesney? Yes, it is. And it's seeking the renewal of D1's credit facilities.
Yes.
Yes. We go on to the next page, I2976.
Yes.
Now we can see towards the bottom of that page, on the right-hand side, it states that the account is SMA2. So it's a special mention account, isn't it?
Yes.
Yes. And then if we go a few pages on to 2981, please.
Yeah.
And 8.3 in the middle of that page.
Yeah.
Yes. Sort of credit information. And the second sentence of that, the operation in the account is not satisfactory. The account is in stress since October 2017. Currently, there are 3 TRs overdue. It says the amount, and a term loan is also overdue. Do you see that?
Yeah.
And then finally, if we can go to 2987, please.
Yeah.
And it's the 4th paragraph down from the top. Net profit.
Yes.
You see there the net profit of the company. There is decrease in profit compared to FY 2016 to 17, mainly due to decline in sales. You see that, don't you?
Yes.
And by November 2018, which is the date of this memorandum, D1 had defaulted on a number of payments, hadn't it?
Yes.
And we saw earlier today that usually when UBI was providing new lending to D1, there was a comprehensive set of documents in support, didn't we?
Yes.
But we don't have that in 2018, do we?
2018, based on the financial documents only, the review would have been undertaken.
It's a review, sure, but there are no renewed personal guarantees at this stage, are there?
You will find in the note that may be clauses relating to personal corporate guarantees.
There are no, Mr. Chesian, I can tell you that there are no new personal guarantees signed by the personal guarantors in November 2018. And there's no additional request for funding in the sort that in the form which we saw earlier. There's no additional request from D1 in November 2018, is there?
No additional request.
No additional request, no. And so UBI shouldn't really have been providing additional funding to D1 at this stage, should it?
Come again, please. I'm unable to catch.
Mr. Chesian, you've agreed. Mr. Chesian, you've agreed that as at November 2018, there was no new request for funding, and you've accepted that there were no new personal guarantees at that date. And we saw earlier that usually when funding was being considered, when it was going to be provided, there was a comprehensive set of documents in support. And we don't have that in November 2018, do we?
Unless there is a change in limits, we will not take fresh documents.
But we don't have those documents in 2018.
Yeah.
Right. And so UBI shouldn't have provided additional funding where it didn't have the benefit of that comprehensive set of documents, should it?
Funding is based on the financial performance and sales projections, and the documents follow the sanction, proper sanction and sanction advice.
Which we don't have in 2018.
Yes, 2018, there is no enhancement. There is no change in the facility.
But we don't have, but we've just seen that there were numerous payments overdue, that there have been a decline in sales and so a decrease in profit, and that the account is classified as a special mention account, haven't we?
Yes.
Right. And there are no new documents at that time, are there?
Yeah.
Right. Now, you mentioned earlier when you were being cross-examined by Mr. Shaheen that recall notices were issued in September 2019. Could you explain perhaps why they were issued at that date and not sooner?
Immediately after the default, immediately after the account being classified as NPA, the default notices were issued. Recall notices.
I'm sorry, I didn't catch that. Could you say it again, please, Mr. Chesian?
Once the account turns non-performing, then recall notices were issued. It follows the account turning NPA.
Now, was the bank aware in summer 2019 of the difficulties between D4 and D5?
Yes.
It was. And then in September 2019, it decides to issue the recall notices, doesn't it?
I'm sorry?
In September 2019, as you've just stated, it issues the recall notices.
Yes.
Yes. Now, UBI is obviously a bank, so its business is dealing with money, isn't it?
Yes.
And that means that UBI and its employees, like you and your colleagues, are familiar with making informed decisions based on commercial outcomes.
Yes.
So if a customer owes a lot of money to the bank, but you know that it has assets which are worth more than that, it would make sense for the bank to try to recover those assets and sell them, wouldn't it?
Could you repeat, please?
Of course. A customer owes a lot of money to to the bank, right? The bank knows that the customer has certain assets which are worth much more than the customer owes. Do you follow me so far?
Yeah.
Yes. In those circumstances, it makes sense, doesn't it, for the bank to try to recover those assets and then sell them, doesn't it?
Yeah.
That's the point of having security, isn't it?
Yeah.
And it would make sense for the bank to try to recover those assets and sell them, even if it had to spend a little bit of money on doing so, wouldn't it?
But that's not our basic business.
No, I appreciate it's not the bank's basic business, Mr. Chesian, but in the situation I've just outlined to you, where you agreed that the point of having security is that you can resort to it if necessary, on occasion, an institution will need to spend a little bit of money on resorting to its security, won't it?
Yeah.
Yes. Can I ask you please to go to I3375, please?
Yeah.
Wait a second. Yeah.
Yes.
Yeah.
Now, Mr. Chesian, if you go to the bottom of that page, you can see that we've got the beginning of an email from D5 to Mr. Manoram, but that you are included in copy. Do you see that?
Yeah. Yeah.
And then if we go over the page to I3376, and just the second line of that, it says that DIC is proceeding with auctioning the assets of VIL to recover the pending rental amount. Do you see that?
Yeah.
And then further down that page, from paragraph 3 onwards, we can see that D5 writes, for the last couple of weeks, I had arranged many calls and interactions between yourself and DIC to secure a workable solution so that the bank does not lose VIL's assets. Now, can I ask you, Mr. Chesian, just to read to the bottom of that page yourself and let me know once you've reached that point?
Yeah. Yeah.
Mr. Chesian, I'm just waiting for the judge to reach that point as well.
Yeah.
Mr. Chesian, can you then just go over onto the next page, please?
Yeah.
And there we see paragraph 8. And D5 states the bank has an exposure of $2.6 million. And by paying less than $0.2 million, the bank can protect its security over the assets without letting DIC auction the same for scrap value. Do you see that?
Yeah.
Yes. But the bank didn't pay that rental income to DIC, did it?
No. We
No.
didn't pay.
You didn't pay, no. And so DIC did auction the assets, didn't it?
Yeah.
Yes. I'm not going to ask you to go to this document, Mr. Chesian. I'm just going to give the reference for the judge's note. My lord, D1's financial statements for the year ending June 2018 can be found at I2871.
So those are what?
These are the financial statements for the year ending 30th of June 2018.
Year ending 2018.
Yes.
Yeah.
30th of June 2018.
Yeah.
Now, Mr. Chezian, in June 2018, in the document which I've just referred to, the property, plant and equipment of D1 had a value of over 14 million dirhams. Are you aware of that?
40 or 14?
No.
14, 1-4.
I'm sorry, what was the number you are referring to?
Let's go to the document. If we go to I2871.
Yeah.
Right. And we see that it states that it's Velocity Industries Director's Report, Auditor's Report and Financial Statements for the year ending 30th of June 2018, yes?
Yeah.
Now, can I ask you to go to I2877?
Yeah.
And then the top, towards the top, you'll see property, plant and equipment. And then if you go along to the right-hand side, you can see in the column which is headed 2018, a figure of over 14 million dirhams, can't you?
Yeah.
Right. So as at June 2018, that was the value of D1's property, plant and equipment, wasn't it?
These are the book values, but market values could be different.
Okay, market values could be different, but they're not going to be wildly different, are they?
These are second-hand machineries. Probably it would get much less.
Well, Mr. Chezian, we know that in fact in auction they did get much less. But the point is that in the financial statements for 2018, this company's property, plant and equipment is stated as having a value of 14 million dirhams. That's just what's on the page, isn't it?
Yeah. Yeah.
Yes. Yes. But in October 2020, the bank didn't think that it was worth paying $150,000 in order to secure the benefit of its security, did it?
Yeah, and did not pay.
It didn't pay, exactly. And the reason for that was alluded to by the bank's counsel in her openings yesterday. And that was because at the beginning of October 2020, the bank had a default judgment in these proceedings, didn't it?
Yeah.
Right. And as far as the bank was concerned, that would be the end of the story, wouldn't it?
Yeah.
Yes. And so the bank didn't seek to mitigate its losses, did it?
Yeah.
You agree?
It's not our business to take position and involved in the sale process.
Mr. Chezian, that wasn't my question. My question, with which I think you agreed, was that the bank did not mitigate its losses in October 2020, did it?
No.
No, it didn't. My lord, should I have a brief moment just to take some instructions? I'll be very brief.
Yes, of course.
Grateful. No further questions, my lord.
Thank you. Now, Mr. Kapoor, It's your turn next. Do you want to, how long do you think you're going to be? I can't hear you. You're muted.
I'm sorry about that. I was just thinking if we could take a 5 or 10 minute break before I start, but I will not
Yes,
take long.
yes.
I will not take more than maybe 25 minutes.
Okay, we'll break for 10 minutes. So we'll make it, it's 10 minutes, it's 10:40, it's 10:50 UK time, which is 13:50. Right.
Right. Thank you.
Thank you. Is everyone present? Everyone here? Is Mrs. Khan attending? Or Mr. Vijani, you're happy to go ahead?
We are happy to go ahead.
Yeah. Very well. Thank you. Yes, Mr. Kapoor.
Thank you. Thank you, Your Honor. And my thanks to Zara for taking over my turn and allowing me some time to fix my technical glitch. Thank you very much. Mr. Cherian, good afternoon. I think we are both on the same time zone, so we can say the same for the same time, please. I will not make it very long because I think a lot of details and the technical details have already been covered by the other councils. I just would like to clarify a few things which are relating to the relationship which we had with the bank. Okay, so D1 was granted facilities by the bank, where D2 and D3 were the shareholders. Is that correct?
Yes.
And is it also true that the shareholders of D2, which is Velocity Ventures, were Vijay and Ravi, and the shareholders for D3 were Mr. and Mrs. Makijani and Mr. Parag Gupta?
Yes.
And at the very beginning, when the account was opened in Union Bank, and I refer to your own witness statement, if you can open it to page G209.
Yes.
And I refer to paragraph 23. Right?
Yes.
Where we say that the first defendant provided confirmation of authorized signatories, one from each list. So list A comprised of that is myself and 7, Mr. Parag Gupta, and list B was Mr. Ravi, which is D5, and D6, Mr. Makijani. Is that correct?
Correct.
Right. And since the case and the claim which has now been filed is against D1 as the first defendant, claim D2 and D3 being the corporate guarantors and the balance individuals at their personal capacity as guarantors. Is that correct?
Correct.
So as per the bank's records, the constituent shareholders and the guarantors have remained unchanged from the time of the sanction of the facility in 2014 till the facility was recalled on the 3rd of September 2019. Is that correct?
Correct.
Right. So just going back to the days when you were personally there in Dubai, I'm referring to the period from 2014 to 2016, right? Is it correct that right from the initial submissions to each and every important meetings or regular meetings with the banks were attended by both D4 and D5?
Almost on all occasions.
Okay. Thank you for that.
Oh, sorry, I didn't catch that. Can you repeat that, please?
Almost on all occasions.
See, thank you.
Right. And from your dealings with both D4 and D5, did you get an understanding that both were equally involved in the running of the business?
Yeah.
And whenever any details of the, what you call requests from the bank for drawal of money or other things were asked for, all requests in that period of 2014 to 2016 were submitted in writing to the bank signed by both D4 and D5?
Yes.
So would it be true to say that D4 and D5 were both aware of the financial undertakings or the financial obligations of D1 vis-a-vis the bank?
Yes.
Now,
Sorry, Mr. Kapoor, I didn't want to interject you, but may I seek your lordship's pardon to do so for a moment?
Yes, of course. Yes.
I'm just wanting to impress upon if the cross-examination can be restricted on the basis of the evidence given by my clients, witnesses, and not on the basis of something which is beyond what he has stated in the witness statement.
No, that's not right. The witness statement contains the evidence in chief, but if the witness can speak on other matters, then counsel are quite entitled to cross-examine on those matters.
Very well.
thank you. And my apologies to Mr. Vajani, as I am not a trained lawyer. I'm just trying to piece the facts together in a simple, commonsensical manner.
I just thought that we're running against time, so if we can, try and shrink all of this.
I promised you that I will finish it in 20-25 minutes, so don't worry about that, please.
Let's not waste time discussing that.
Yes, please. Okay, so we also know that the Claimants Council, Kocher and Company, have been involved both at the time of the facility documentation, which was done in 2017, and thereafter subsequently advising the claimant. Is that correct?
I'm not aware of that. I was not there during that period.
Okay, but can we say that because during the period from 2018 to 2021, you were supervising the international operations and the branch, you would be privy to the the basic day-to-day operations and the way the committees are formed to how or what is happening at the branch level, especially when there is an account which is not necessarily in the right frame?
I'm sorry, this is not part of my witness statement.
Right. Okay. So maybe I can move on from this.
Mr. Chairman, it may not be part of the witness statement, but if you have any information in answer to the question, you must answer the question.
Yeah, I was not privy to that information, sir.
Thank you.
So just to rephrase and re-emphasize, you were aware of the involvement of the Claimants Council in advising the claimant during that period of from 2018 to 2021, right? Is that correct?
No, I was not aware, because these documentation happen at DAFC branch.
No, my question is not about the documentation. I'm talking about whether the Claimants Council was actually advising the claimant during the period from 2018 to 2021.
I was not aware.
You're not aware. Okay. Let's move on from there. Are you aware of a submission which was made by me as D4 to the branch in the December of 2018, where we had made them aware of a large contract which could have been signed which would be to the benefit of D1?
I don't remember, please.
Okay, fine. I'll maybe check this with Mr. Maniram, because he would be more, involved on a day-to-day basis in this matter. My next question concerns the events where there was an event of default and a default notice was served on D1 on the 3rd of September 2019. Is that correct?
Yes.
And at that point of time, the bank was fully aware that the shareholding, as per their records, and the signature mandates, as per their records, had not been changed.
Yes.
So you were aware of a conflict between D4, which is myself, and D5 during the intervening period of 2018 to 2019?
Yeah, we came to know from the branch.
Right. And when you were aware of this conflict, the direct result of that conflict was that day-to-day operations were not able to be performed because of either lack or reluctance of signatures from D5 in regular business transactions.
That's not there in the statement, please.
No, I'm not addressing the statement. I'm asking you a fact, whether you were aware from the branch under your supervision, were you aware or advised by the branch about this situation?
Branch indicated that there were some differences of opinion between D4 and D5.
Right. But other than the difference of opinion, there was correspondence and communication from D5 to the branch clearly stating that his digital signature should not be accepted and only personal signatures and original should be obtained. Were you aware of that?
No.
So you are not aware. Okay. So I'll then move on to, since you are not aware of many of these situations in the branch as a supervisor of the branch, I'll move on to my next question. When a company is in distress, is it not common practice or an established banking practice to call for a meeting of all the stakeholders to find a way, or to at least discuss a way of resolution and move forward?
It's not the bank's duty to involve in some sort of reconciliation.
No, you misunderstood my question. My question was, as per established banking convention, protocol and practices, if their account is in distress, is it not normal to call for a meeting, a lender's meeting with the borrowers, with their representatives, as well as the guarantors, at least an intimation to seek such a meeting? Is it that not a normal practice?
As far as I know, frequent meetings happened between the borrowers, either D4 or D5, with the branch officials.
So, Mr. Cherian, you just mentioned that you are not aware of the day-to-day things which are happening in Dubai, but when an account is in distress, it has to be escalated to a higher level, and you were the higher level, right? Yeah. So I, being a banker, a former banker myself, know for a fact that in every bank, as a part of the remedial process, there is a protocol to call for a meeting of all stakeholders. Whether the people attend or not attend doesn't matter, but there is a protocol to call for a meeting of all stakeholders so that a resolution may at least be sought. It does not have to be corrected, right? Is that correct?
Yeah, but informal meetings were happening. Informal calls were taking place between the borrowers and the bank.
No, my specific question, Mr. Cherian, is to call for a collective meeting, and I could perhaps bring some examples of the same bank with the same group of companies where a complete meeting of all stakeholders were called for and minutes were recorded. So I'm just alluding to that practice as a general practice, which was something which I experienced in another group company's matter. So I'm just asking whether that is a normal practice and is it something which was done in this case or not?
It might be that the concerned persons were not available for attending the meeting together to attempt some sort of patch up.
Yeah. So, Mr. Cherian, I accept the fact that there might have been reluctance on the part of people to attend, but was there ever even a single communication, an email which was sent out to all the stakeholders calling for a meeting of all, inviting them to attend a meeting to seek a resolution?
Informal attempts were made from the branch.
Okay. So, I would like to again question and close the question at, was an email sent by the bank to communicate with all the stakeholders calling for a formal meeting?
That's not part of my statement, please.
Mr. You keep saying something is not part of your statement. That doesn't matter. If you're asked a question, you may know the answer, you may not know the answer. If you know the answer, then you must give it.
Yes, madam.
Right, do you want to?
Should I re-put the question to you, Mr. Cherian?
If you re-put the question once.
Yeah. My question is, did the bank, whether it's at the branch level or at a supervisory remedial level, ever seek or send out an email, a formal email, to all the stakeholders calling for a meeting to discuss the distress situation?
There were only informal attempts were being made. No formal attempt was made.
Thank you. Now, what we have to look at in this situation, and I just at this point of time, I'm not just simply addressing the witness, but I'm also bringing out the point which you had, Your Honor, had requested me to bring up at the appropriate juncture regarding the conflict. So
we'll do it by way of asking questions.
Okay. Then, Mr. Cherian, were you aware of the advice given to D4, which is myself, by the claimant's lawyers about the way the shareholding or the signatory powers of D1 could be amended?
I'm not aware.
You are not aware. Okay. So I'll reserve this question again for Mr. Maniram, because since he was handling these matters on a day-to-day basis. Since the facility, the amount was large, it was almost more than $2 million, do you think in your professional and senior banking opinion that a formal communication should have been sent by the bank seeking for all stakeholders to be called for a meeting?
Since the stakeholders were not available, some of the stakeholders were not available in Dubai on and off, they were traveling. So all communications remained at the informal level.
Mr. Cherian, my question is very specific. In your opinion as a senior banker and as the supervisor of the DIFC branch, should a written email have been sent or written communication have been sent to all stakeholders calling for such a meeting?
The branch was in constant touch with all the stakeholders.
No. You specifically said there was no written communication. My next question was, as a senior banker and the supervisor of the DIFC branch, in your opinion, should such a communication have, a written communication should have been sent or not?
It has not been sent.
Yeah, should it have been sent is my question, because you were the supervisor of the DIFC branch.
Since there were differences among the stakeholders, it might not have yielded any result.
Your Honor, my question is very specific and I would request the witness to answer it. I'm asking you, as since you've already shown that you have significant experience, you were supervising a branch, the branch was reporting to you and you're heading the international business. Such a written communication, should it have been sent or not? That is my only specific question. In your opinion,
It could
and
have
you want to
been
explain
sent.
it or not sent?
It could have been sent.
Yeah, okay. Thank you very much for that.
It could have been sent. Could have been sent.
It could have been sent.
The answer is it could have been sent.
The
So-
attempts are always there.
So
I'm sorry, I didn't.
There were attempts on the part of the branch officials to be in touch with all the stakeholders and to bring them around. It remained informal.
So I'll rephrase the question. Should such a communication have been sent?
Yeah, it should be sent.
So since you are not aware of the day-to-day dealings with the claimant's counsel and whatever advice was being given, I would probably not ask those questions from you at this stage. I'll reserve those questions, for your colleagues who are probably more hands-on at that point of time. I have no further questions, Your Honor.
Thank you very much.
Thank you.
Now, Mr. Vajani, is there any re-examination, or do
Yes,
you want to break?
No, I would like to re-examine, but that's going
Yes.
to take some time. So if your lordships want to take a break for lunchtime, we can proceed to lunchtime.
Tell
I
me,
can
how long do you think you'll?
At least about 30 minutes.
What time is it now? Why don't we let's leave a lunch break until afterwards, if that's convenient to everyone. Sorry, I'm not sure about Dubai time.
Past lunchtime, almost.
Okay, well, how long do you want to break for lunch? 40 minutes?
That's fine for us, no problem.
Is everyone else happy to break at this stage for lunch? Right, we'll break now and we'll resume at, let's make it, it's 11:15 now UK time. We'll resume at 5 to 12, which is 5 to 3 Dubai time. Mr. Chezian, if you want to walk around and get some lunch, please do so. But if you can be back in 3/4 of an hour, 45 minutes.
Thanks, my lord.
Sorry, 40 minutes. And don't talk about the case in the meantime. Thank you.
I'll not do it.
Okay, thank you.
Thank you, Lordship.
Thank you, Your Lordship.
Are you ready to please?
Yes, Your Lordship.
Yes. You're muted.
Can your Lordship hear me?
I can hear you now, yes.
Yes. With your Lordship's permission, may I begin the re-exam?
Yes. Go ahead.
Mr. Chezian, when you onboard a customer, the process that is followed, can that be described by yourself?
Yeah. When we onboard the customer, we undertake customer due diligence, know your customer. We do a address check, identification check, employment verification, credit check, then criminal record check, then employment history and the professional designation, then CIBIL check in case of Indian national CIBIL check. All those checks we used to undertake.
My learned friend showed you the documents with regards to the onboarding process, which my learned friend described to be a thorough check done by you. Is there any other additional process that you would have undertaken should it have been any other customer?
No, this is the normal due diligence process that is being undertaken.
After the onboarding is done, I assume the sanction letter is issued.
Yes.
May I object, Your Honor? Your Lordship, questions in re-examination cannot be leading questions. He's asking after the onboarding process is done, you issue a sanction letter. Yes or no? This is a leading question.
Yes.
Well,
there are different views about whether you can ask leading questions in re-examination, but Mr. Vajani, try and put your questions more neutrally. But sometimes if it's obvious what the answer should be, you can lead and then don't lead at the difficult moment.
Yeah.
Anyway,
I from your lordships and my learned friend, Mr. Shaheen, I'll take care of that.
Thank you. Carry on. I can't hear you, Mr. Vajani.
What is the distinction between the sanction letter and the facilities agreement?
Sanction letter is a sanction intimation to the borrower, and the facility agreement follows the sanction letter.
What is the difference between the facilities agreement and the renewal thereof?
Whenever enhancements are undertaken, normally facility agreement follows the serving of the sanction letter. Sanction letter is an intimation to the borrower that such and such facility has been sanctioned. The currency, the amount, the tenor, nature of facilities, all those are indicated in the sanction advice. Based on the sanction advice, facilities agreement is prepared.
My question was, what is the difference between the facilities agreement and the renewal thereof?
I'm not getting.
Can you hear me clearly?
Yeah.
What is the difference between the facilities agreement and the renewal thereof?
A renewal letter is renewal of the facilities is being undertaken every year. After the renewal is undertaken, a renewal sanction advice is served on the borrower, be it with the enhancement, without the enhancement. If there are any changes, that will be intimated to the borrower by means of a renewal intimation.
Mr. Chezian, you were going very fast and I didn't pick up what you were saying. Sorry, it's my fault, but you were going quite fast. Could you repeat that a bit slower, please?
Yes, renewal sanction advice is the renewal is served to the borrower after the renewal of the facilities that are already enjoyed by the borrower. So whenever there are any changes in the facilities enjoyed by the borrower, an amended facility agreement is being prepared. You are muted. You are muted, sir.
So a facility agreement is not required every time there is a renewal?
It's not required unless there is a change in the facility. A new facility agreement is not.
Mr. Vajani, that was a terribly leading question and it didn't follow at all from the previous answer. So could you please be careful, because it won't help your case if the evidence comes out in the form of answers to leading questions. Yes, Mr. Shaheen.
That's exactly what I wanted to say. Very serious objection here. I want from the beginning the way it was done.
I've dealt with the objection.
Thank you very much.
Mr. Vajani, would you try and rephrase that question?
Acha.
Have we lost you?
No, I'm here. I'm here in the documents. I was just trying to see how to put it differently. I will just come back to that question separately.
Thank you.
Under what norms is a current account to be closed if an account is declared NPA?
Only when the facilities enjoyed by the credit facilities enjoyed by the borrower are adjusted, the current account will be closed.
Can you take your witness statement?
Yes.
And come to paragraph 29.
Yes.
G212 for your lordship's reference.
G what?
212.
212. Yeah, I have that, yes.
On what basis is this calculation made?
This calculation is based on the 2,288,000 is the outstanding facility amount, and the others are interest accrued, interest payable on the interest due date. And if at all some penal interest is there, that will also be added. If the amount remains overdue beyond a certain period, beyond the period given to the borrower, then penal interest is also added.
Is penal interest part of the contractual obligation?
Yes.
And that contractual obligation is signed by the borrower?
Yes.
Is this calculation done manually?
It is done by the system. It is done by the core banking solutions, Infosys Pinnacle core banking solutions.
Sorry, say that again. I couldn't hear you.
It is extracted from the core banking solutions, Pinnacle core banking solutions.
What is Pinnacle core banking solutions?
It is a software of Infosys used in the banking, extensively used in the banking operations.
Is penal interest a regular norm in the facilities agreements that you would enter within the UAE?
Yes, penal interest is a regular norm. It is entered in the facility agreement. If there is overdue, then penal interest will be charged.
If there is non-repayment of any debt, would that cause any loss to the bank?
Loss of interest, then a bank needs to keep provision on the amount that is coming from the profit and loss account. So
sorry,
that is
I can't. Sorry, Mr. Chairman, I can't hear you. I don't know if it is the network issue at my end, but I can't hear you.
Interest loss, once the account turns NPA, interest cannot be charged in the account, that is a loss, and bank needs to keep provision for the non-performing asset, that is a loss, and the amount gets locked up, which cannot be relent.
In paragraph 29, of your witness statement at G212.
Yeah.
You have used for non-payment and suffered losses. Could you explain the same?
Yes. The contracted amount has not been paid back in time. On the due dates, the amounts that were supposed to be paid by the borrower were not paid.
In your cross-examination, sir. I seek my lordship's pardon for Mr. Chairman to have had water.
Yeah.
Yes.
In your cross-examination, you mentioned that normally, as per your personal perception, the bank would have stepped in and paid the rents. Would the bank still do so for a NPA account?
After the account turning NPA, there is no permission to debit the account. So it would not have been possible for the DFC branch to debit the account and make the payment, make the lease rent payment.
You also mentioned that these debits could have ordinarily been made to a current account. Was there, in your knowledge, any monies available in the current account of the borrower at the relevant time?
No, I think most of the monies have already been adjusted towards the overdues.
Mr. Cherian, you had served at the DIFC branch for the period 1st December 2013 to 16th May 2016.
1st February 2013.
1st February 2013 to 16th May 2016.
Yes.
And the record shows that during that period, there were various transfer requests that were received. Some of the samples my learned friend Ms. McClone showed you. Was there any default or overdue in respect of these transfer requests during your tenure?
My lord, I'm sorry to cut across my learned friend, but it does rather seem that we're having a series of leading questions here, which is not appropriate for re-examination.
This was not a leading question from any angle.
I thought that was one of the. I thought that was one of the few that wasn't a leading question.
Yes, wasn't a leading question.
I had waited for him to finish about the previous ones.
Well, I've made a note when the answers have been given in response to leading questions, and it doesn't help me assess the weight of the evidence to be given to the evidence. Yes, Mr. Shaheen, you want to say the same thing?
Yes, Your Lordship. It's not just about the leading question. The purpose of re-examination is clarification of any ambiguity in the cross-examination. Is not to explain every sentence a witness spoke in the cross-examination. There is a big difference there between explanation and clarification. My learned friend's questions are all, you said so and so, explain. This is not the purpose of re-examination, Your Lordship, with all due respect to my learned friend.
Mr. Shaheen, the distinction between clarification and explanation and so on is always slightly obscure, and I will intervene if I think the questioner is going too far.
One question, I will take it an example, Your Lordship, regarding the payment of the rent, an obligation which the witness accepted. Afterwards saying that it was NPA, no money available, every sentence was suggested, and then asking the question. This is not a clarification, Your Lordship.
Oh.
A clear statement which came in the cross-examination, what is brought out in the cross-examination is being destroyed.
Well. I can't undo what's been done, but you can make a note. And Mr. Vajani, if you take care, please.
I am taking most care, but as I see, we have defenses which are technical and objections also which are technical, but I will take due care. When we deal with, there are objections which are very technical in nature because my last question was not leading from any angle whatsoever.
I think Ms. McGlone apparently was referring to the previous line of questioning.
After I finished questioning, after the answers come on record, after I've asked the next question, then you raised the objection. I obviously thought that it was to the last question.
Okay, anyway, can you?
I will take due care, Lordships. I will take that.
Take due care and carry on, please.
Deeply obliged. Your Lordships may give me 2 minutes because I've lost the thread where I was. Just your Lordships.
Yes. We'll stay in line.
If you can go to page I-1790. And I'm only referring to the document what my learned friends have shown so that we restrict our limits to that.
1790.
Yes, Your Lordship.
Yes.
Does Your Lordship have it?
Yes, I do.
Yes. Mr. Chariot, what is the purpose of the world check? Risk.
World check, whether any news about the company is the world check collects all the information about the companies all over the world and updates it on a constant basis. And it is told that a minimum 2 lakh updations happen every hour. It collates information about the companies and the businesses.
Why is this process undertaken by the bank?
It is the form of due diligence. To know any wrong information that is not otherwise available in the market, to know about the company's dealings or the promoter's dealings, anything related to the company's or the promoter's dealings all over the world are captured here.
May I request you to now see I-1786. Your Lordships, this document begins at I-1785, and this is a document which is titled as Trust Receipt, and it relates to the same transaction which my learned friend Ms. McGlone was referring to with regards to Launchpad General Trading Incorporation, LLC.
Right, so the trust receipt starts on page 1784.
1785. 1784 of the record is a form of utilization notice.
We have a different, are we talking about? Oh, sorry. I was doing the problem with the eyes again. Wait a second.
Rashid has it?
Wait a second.
Yes, yes.
1786. Okay, yeah. Yeah.
This clause was put.
At 1786.
Yes.
Specifically clause 9.
ये documents कौन देता है?
Does the bank assume responsibility of the due diligence?
No. No.
I speak your lordship's pardon on one count, and since there is no live transcription, I have a little handicap. If the question that I had asked my learned friend, who's a witness, with regards to the transfer receipts during his tenure to have been defaulted or overdue, I don't know if that got recorded and his answer got recorded. If not, then I'd like to put that again.
I'm not sure what question you're referring to, but rather than say out loud with the witness, you can ask the question in a non-leading way and see what happens.
I'll make the best endeavor. During your tenure at DIFC branch, the transfer receipts were not under any default or overdue.
But if you, Mr. Vajani, that is a statement, not a question. And you've told him the answer. Mr. Shaheen, please be quiet.
There's a answer, Your Lordship, not even a question.
Mr. Shaheen, please, I'm trying to speak to Mr. Vajani. That was a question. That was not a question, and you told the witness the answer you wanted. So I'm not going to make a note of that. If you want to ask a question neutrally, you can do so. But I'm going to stop the cross-examination if it turns into a whole series of leading questions.
I have only two more questions to ask my learned friend. I'll repeat this question. Was there any default or overdue during the tenure that you served at the DIFC?
There were no defaults in the trust receipts or other transactions during my tenure at the DIFC branch.
May I request your lordship and my learned friend to now take I-2975.
I-2975. Yep. Mm-hmm. Yep.
And then which might let the witness.
I can't hear you because you weren't looking at the microphone. I think. Could you say that again, please?
Is your lordship able to hear me now?
I can hear you now.
This is the document which my learned friend Ms. McClone showed the witness.
Yes.
And I would want to draw the witness's attention to I-2992.
Yes.
Specifically, clause 19.2.
Yes.
Are the personal guarantees continuing under this memorandum as well?
Yes, the documents are in force. Personal guarantee and corporate guarantees are in force.
I have stuck to my time, your lordships. I have no further questions.
Thank you very much. That's the end of your evidence, Mr. Chesian. So thank you very much for being with us, and you're free to go now. Thank you.
Thanks. Thanks a lot.
Right. Presumably the next witness is Mr. Kumar. Is that right? Mr. Vajani, where have you gone to? Is Mr. Vajani there?
Your Lordship, he is logging again. He has been, you can say, logged out.
All right. Okay, we'll wait for a moment.
My apologies, your lordships. I was logged out.
Right, not to worry. It happens sometimes. Yes. Are you ready to go on with your next witness, or do you want? Does he need? Where is he? Is he in the right place?
We will just ask him to log in. He's here.
Are you happy to go straight on?
Yes, yes, your lordships.
Very well. Are you Mr. Kumar? Mr. Akhilesh Kumar?
Yeah, Milad, I am Akhilesh Kumar.
And what I'll do is I'll ask the court clerk to administer the oath, if that's all right. Maitha?
Yes, Judge. Good afternoon, Mr. Kumar. Could you please state your full name and occupation?
I'm a banker associated with Union Bank of India for the last 26 years.
Cross-examine him again.
Thank you. Okay, would you please confirm whether you'll be taking an oath or affirmation?
To be affirmation.
Affirmation. Thank you. Can you please repeat after me? I solemnly declare and affirm.
I solemnly declare and affirm
that the evidence I shall give will be the truth.
That the evidence I will give be the truth.
The whole truth and nothing but the truth.
The whole truth and nothing but the truth.
Thank you.
Thank you very much. Right, Mr. Vajani, you're muted.
Mr. Kumar, can you state your full name for the record as well as your address?
I am Akhilesh Kumar. My address is A/23 Magistrate Colony, Patna, Bihar, India.
Mr. Kumar, what is your qualification and your current position with the bank?
I am agriculture graduate. In addition to that, I did my MBA also through a distance learning program. I am a certified associate of Indian Institute of Banking and Finance. My current designation is Deputy General Manager in Treasury Department of Union Bank of India, Head Office.
Very important.
What do you mean by Bachelor of Agriculture?
We have a technical education in agriculture science, and we studied 4 years for agriculture science.
Is that required for the banking business?
Yes, it is required.
Why?
Bank recruits some specialist officers for carrying their agricultural operations. That's why they need agriculture graduates.
You have given a witness statement which is at pages G217 to G223. Is that correct?
Yes, correct. G21. Yes, correct. 2 to 3.
You have this statement physically or electronically with you?
I have physically.
You have in this statement referred to exhibits C15 to C29, sorry, C15 to C138 and listed at G224 to G229. Is that correct?
Electronically, I have these documents.
No, first you'll have to answer that you have referred to these in your witness statement, which are enlisted from G22 at G224 to G229 as exhibit C15 to C138.
Electronically, I have.
I'll repeat my question. You will have to first confirm that you have referred to the exhibits, exhibit C15 to C138 and listed at G224 to G229 in your witness statement.
Yes.
Do you have a copy of these documents physically or electronically?
Electronically, I have.
On the physical copies available with you with regard to your witness statement, have you annotated or marked anything on the same?
No, nothing.
Could you turn to page G223? Could you confirm if this is your signature?
Yes, it is my signature.
Could you confirm the date to be 23rd December 2021?
Yeah, I confirm.
Do you wish to clarify anything with regards to your witness statement?
Except at G218. At para 4, when I submitted this statement, I was posted in Bhopal, Madhya Pradesh. Thereafter, my services has been transferred and I am in Mumbai right now.
Is there anything else that you would like to clarify with regards to your witness statement?
No.
I am deeply obliged. No further questions, Your Lordship.
Mr. Shaheen, do you want to go first again, or has some other agreement been reached?
I can get it. I can begin the cross-examination now.
Yeah, do you want to start now? Do you want to break, or has something else been agreed?
I can continue.
I'm ready to. Okay, let's carry on. Right.
Yes. Mr. Akhilesh Kumar, where are you now?
I'm in Mumbai.
Mumbai in India.
Yes.
Yes, okay. Have you taken the special permission from the concerned competent authorities to give testimony in this case before the DIFC court?
My internal department authorities are aware about it and they have permitted.
Your internal authorities have approved. The government authorities, you have not taken any approval.
I personally have not taken any.
You have not taken. You say that you are a representative of Union Bank of India, DIFC branch. Are you a representative of Union Bank of India, DIFC branch now?
No.
No. So that statement is wrong. Paragraph number 1 in your witness statement.
I can say it was a typo.
Any proof that you're authorized to represent Union Bank of India?
At that time, when I was in DIFC?
No, I'm not talking about DIFC branch now because you said it's a typo. I'm asking you any proof that you're authorized to represent Union Bank of India?
Yeah, from witness point of view, I am authorized.
You are authorized. You are not produced any such document before this honorable court.
As witness?
Yes. Have you produced any document confirming your authority to represent Union Bank of India before this honorable court?
As witness, I was asked.
Okay.
Mr. Shaheen, I'm not understanding the relevance of that question. A witness is a witness. If he's authorized, he's authorized. It doesn't matter. If he's not authorized, he's still a witness.
The statement in the witness statement, I'm going sentence by sentence from the witness statement. The statement in the witness statement claims that I'm a representative of Union Bank of India. I'm entitled to ask that question, Your Lordship.
Yes, you are. Yes.
Thank you, Your Lordship. You said the bachelor degree in agriculture was required for your position in the bank because the bank gives facilities for agricultural works. How many facilities did you grant from DIFC branch for agricultural needs during your tenure here?
This agriculture degree was required for recruitment, and at that time, in initial 3 or 4 years, we used to finance agriculture operations in India, farmers especially, or rural areas. That's why bank recruits agriculture graduates. Thereafter, after 4 or 5 years, they comes to all general banking operations and all type of operations we carry.
No agricultural loan was ever given from the DIFC branch.
No.
So your qualification was. Please.
Millard, may I be permitted to clarify?
Please, please.
Yeah. Bank recruits specialist officers for carrying out some special type of activities. For that purpose, for agriculture financing, bank recruits agriculture officers. But after after over a period of time, like 3 years, 4 years, or 5 years, those officers are not supposed to continue for agriculture financing for throughout their life in bank. They move to other departments also as requirement of the bank, and during that course they go through other operations, other banking operations too. Precisely to answering to your question, no, in DIFC Dubai we have not financed any agriculture finance.
Thank you. So your qualification in agriculture was anyway of no relevance for your tenure during your tenure in DIFC branch.
We cannot say like this, because it's an experience, and such experience may count anywhere.
Okay.
For any type of activity.
Okay, I go to the next paragraph. Paragraph number 5. Where the facts are within my knowledge, they are true. Where they are not within my knowledge, they are true to the best of my information and belief. This is your statement. Is it possible to distinguish such statements in your total witness statement, which are within your knowledge and which are not within your knowledge? Is it possible to distinguish them?
Yeah, it may be. Like in this ongoing trial, so many things came which I was not aware, I was not knowing.
I'm not talking about the general, I'm talking about your witness statement. That is what you stated in your witness statement. Where the facts are within my knowledge, they are true. Where they are not within my knowledge, they are true to the best of my information and belief. Can it be distinguished or not? Very simple question.
That's what I told. But
okay,
when I was there.
It's all right, no problem. Your tenure was 2015 to 2018.
Yes.
Right? So you wouldn't be aware of what transpired prior to 2015.
Not all, but through documents, I am somewhat aware.
No personal knowledge, that's what I mean. No direct knowledge, no personal knowledge.
Sorry, I could not get you.
No, from the documents, of course, you would have reviewed the documents which happened prior to your tenure. Of course, I understand that. But you did not have any direct information. Or I'll put it in a different way. Did you have any role with the operations of DIFC branch prior to joining the DIFC branch while sitting in India?
No.
Did you have any supervisory role over the activities of the DIFC branch after 2018?
No.
So you are strictly, your knowledge is limited to, personal direct knowledge is limited to February 2015 to March 2018.
Yeah.
Yes. Mr. Cherian's tenure was different, and he had a supervisory role also. Mr. Maniram's tenure was also different compared to yours. I'm asking this question in relation to paragraph number 7. those two gentlemen who are your colleagues, their tenures were different than yours. Mr. Cherian started earlier and continued as a supervisor from India. So he had an overall knowledge about the transactions happening in the IFC branch. Mr. Maniram came much later and continued till almost 2021. Correct? Because you were between 2015 to 2018.
Yeah.
So your statement that you confirm that from facts within my knowledge, own knowledge, and to the best of my information belief, all of the matters referred to in Mr. Cherian's and Mr. Maniram's statements are true and accurate. What do you say about it?
Through documents, whatever documents were available, and I went through on that basis, I am telling.
Did you verify the documents after 2018 concerning the IFC branch? You said you had no role.
Yeah, no.
Then how do you say based on documents? That's why I asked you all those questions before.
No, I have gone through statements of Mr. Chejian and a statement of Mr. Maniram. From there, I came to know.
Okay.
That's what I wrote in my written statement.
Now I'm reading from your witness statement, then I'll have to read it again. I confirm that from facts within my own knowledge and to the best of my information and belief, all of the matters referred to in Mr. Cherian's and Mr. Maniram's statement are true and accurate. I say it's an overstatement. If it's a typo, you can say that.
No, to my belief, it is correct.
Okay, it's your belief. Now, coming down to paragraph number 10. Second line. Operational backdrop to the facility agreement. What do you mean by operational backdrop? Can you enlighten me?
Operational backdrop means whatever operational matters are that we have to taken care of, and that should be as per the facility agreement.
Okay, that's your explanation.
Yeah.
Now, why is a renewal required? If something is ongoing, continuing, we don't have to renew it, right? A renewal is required when there is an expiry or a termination. Am I right?
Renewal in banking, renewal is a normal process. Whenever bank extends any credit facility, then it gives a time period. No facility can be ever continuing. And
yes.
a standard ways for working capital facility, these are for 1 year. After 1 year, or at that time, bank review again how the operational experience bank has, what is the health of the company, how the sales or other things the company projected are going on. To assess all those things, bank review and renew the facility. Normally,
if you
it is 1 year tenure.
Normally, a facility is only for 1 year, and the bank looks at various aspects before renewing the facility. This is what you try to say.
Yeah.
Did I understand it correct? Yes. So if you don't renew a facility, what happens?
May I be permitted to tell in some explanatory way?
Be brief because it's limited time, but you can explain.
Oh, okay. Thank you. It is in any ongoing business, bank cannot withdraw overnight. That's and on this date your facility has expired and we cannot continue, because in business the businessman's money has been engaged so many places with so many traders or business like this. He cannot withdraw those money from all of those and tell that you just liquidate my loan. In that case, if bank is not agree to continue the facility, then bank give a notice to the borrower that we are not going to continue the facility. It is
And
like,
okay. Once a facility is not renewed, strictly speaking, the repayment is due.
can you explain, please?
Once a facility is expired and not renewed, the repayment date is falling due. It's due for repayment. Whether you claim
No.
it or not, it's a different question.
No, unless we send a claim, recall, or tell the party that you just adjust. We cannot unilaterally tell.
No, what I said is, sorry, I may clarify my question. See, I said you may claim, you may not claim. But in theory, the practice is you may claim, you may not claim. That's up to you. But in theory, once a facility is expired, once it is not, and it is not renewed, it is due for payment. In theory, that's how your facility agreements are worded.
No, it is not. It doesn't happens like this.
Should I confront you with the clause now? Clause 2.4 of the facility agreement?
Facility, that is a, I can say that facility agreement is a legal document, and my legal counsel will be in a better position to answer those things.
Okay,
I can
fine.
tell the banking.
I spare you from that question. Fair enough. Now, you said that your statement outlines the immediate contractual connection as well as the operational backdrop to the facility agreement renewal and the payment failure during your tenure, 2015 to 2018. What were the payment failures?
Yeah. This is, as earlier para, I have mentioned that I have gone through the statement of Mr. Jitendra Maniram and Mr. Chejian. In Mr. Maniram's statement, it is observed, I have found that there was payment failures. But
that is
during my tenure, there was no payment failure.
During your tenure, that is 2015 to 2018, there were no payment failures at all. Okay. Facility enhancements were given during 2015 to 2018.
Yeah.
And verification of utilization request, which you stated in paragraph number 10B. Verification of utilization request. All the utilization requests are to be signed by the authorized signatories. Am I right? Any problem? You're not able to hear me?
Yeah. Initially, some breaking of voice was there. But
should I repeat the question?
Understood that you. Please.
Should I repeat the question? I'll repeat. When you verify the utilization request, as mentioned in paragraph 10B, you verify whether the utilization request is properly signed by the authorized signatories on behalf of the borrower, and what is the purpose of the utilization request, whether it is for the intended purpose or not. These are the two things you verify. Am I right?
Yeah.
So, what if a utilization request was not signed by the two signatories required under the board resolution of the company, the borrower? What would you do?
During my tenure, such instance never came.
Never happened. Can I ask a hypothetical question? If it happened, if it was signed only by one signatory, what would you do?
If it is hypothetical question, then please it should be treated like this. My answer should be treated like this. In such scenario, it depends upon the emergency, prudence, why the second or other signatory is not available, whether his consent in taking to consideration in a comprehensive way, a decision can be taken, because it may hamper or it may badly adversely affect the ongoing business of the company.
Okay. Monitoring the repayment from April 2015 to March 2018. Were all the repayments in order? On time?
As I recall, all payments were on time.
Okay. (11.1). Paragraph number 11.1. Enhancements to the facility were made under a sanction letter for the years 2015 to 2019. One sanction letter for 4 years or 5 years. Can you show me a copy of that sanction letter? Second line, last words, under a sanction letter for the years 2015 to 2019. So 15, 16, 17, 18, 19. For 5 years, one sanction letter was there. Have you produced a copy of that sanction letter before?
No,
the
yeah. It is for 1 year. It has been interpreted like this. Actually, the interpretation or the meaning of those lines are that during 15 to 19 accounts were renewed and sanction letters were issued.
So your statement under 11.1 referring to a sanction letter is incorrect.
You can interpret, but it means 15 to 19 each time one sanction letter was issued.
That's your clarification, but it's not my interpretation. A sanction letter is singular. It's very clear.
Each year.
It's not stated so. Okay. And the amended facility agreement, again singular, for 2016 and 2017. So for 2 years, you issued one amended facility agreement.
Whenever there was amended facility agreement was there. As I recall, there was only one amended facility agreement.
There was only one amended facility agreement. So that statement is correct. That part of the statement is correct. Am I right? There is only one amended facility agreement for the 2 years, 2016 and 2017. So that part of your statement is correct. That's what you're confirming now.
I believe.
Okay. Why facility agreements when there are sanction letters? Do you take the signature of the borrower and guarantors on the sanction letters?
Normally, when a bank's first time give any sanction or approve any credit facility to any party, they give sanction letter and take the acknowledgement. Acknowledgement means that they are agreeable to the terms and conditions. In sanction letter, bank broadly writes down what will be the terms and conditions for everything. In facility agreement, they are, I believe, they are transformed into legal terms.
Okay. So when a new facility is being granted, you will first issue a sanction letter. Right?
New as well as renewal. Renewal also. Renewal or
Renewal also
enhancement.
you will issue sanction letter. So renewal is also
enhancement.
So renewal is also a new sanction or a sanction by that means.
No, as I told earlier, each year the account is renewed, and when bank has renewed the facility, the bank used to intimate it to the borrower through sanction letter that yes, your credit facility has been renewed or enhanced like this.
So it's not a renewal letter, it's a sanction letter you issue every year.
First, yeah.
Please say, because it's being recorded.
Yeah, first time it is purely sanction letter, and second time it is sanction and renewal or enhancement letter.
Enhancement letter or sanction and renewal letter. First time when a facility is granted, you issue a sanction letter. Afterwards, it's a sanction and renewal letter or an enhancement letter. Right?
Yeah.
Okay. So when you see only a sanction letter, is it correct to assume that this is a new facility? There is no renewal, there is no enhancement in that letter. It is just a sanction letter. Can I assume that this is a new facility? General banking practice?
No, not always.
Okay. How is that then? You said that I'm going to the next question from your answer. No answer?
I could. May I request for to repeat the question?
Yes. When there is a sanction letter, which does not say it is a renewal letter or an enhancement letter, just a sanction letter, is it right for me to assume that it is with respect to a new facility? There is no mention of renewal, there is no mention of enhancement. It is a sanction letter. Is it right for me to assume that it is a new facility?
One should not go through entirely just catching one word sanction. Whatever is written inside the sanction letter will clarify that whether this is renewal also or enhancement also, or it is a first time sanction.
Okay. So it's not the heading, it's the contents what matters, right?
Yeah.
5th January 2019. Do you have access to the case bundle? I3137.
January 2019.
Yes. I3137.
Actually, I am at that time, on that date, I was not in DIFC.
So you are not aware of it?
Yeah, I am not full versed with that.
Okay. So you're not aware of it. And you are mentioned under 15.1, there was a facility agreement dated 25 November 2017. And this is the subject of this dispute. Right?
Yeah.
This facility agreement expired in June 2018. June, right? 12th June 2018.
No, 12th June. No, where it is? Can you?
2.4. If you have the facility agreement with you, 2.4, clause number 2.4.
As I told, this with regard to facility agreement, it would be better if it is discussed with the legal counsel.
Even the facility agreement during your tenure, you are not able to speak about it.
No, it is not like that. But the legal angle, only legal counsel will explain.
Legal counsels are not witnesses, unfortunately. I have to ask you. You were the manager handling the matter. You were instrumental, you wrote in your witness statement in giving this facility, and you were involved in enhancement of the facility, drafting the facility agreement, backdrop, business backdrop checking, everything. So a facility agreement contains a clause. You referred to that in your witness statement under paragraph 15.1, and you refer to the facility agreement as the subject of this dispute. So I assume that you should be aware of it.
Yeah, for that matter, I am aware.
So you don't know when it expired.
Can I open the document?
Sure, why not?
Can you give me the reference again, please? Can you give the reference?
H347. Are you sure? H347.
Yeah.
Clause 2.4. Fourth line. The borrower may no longer make any utilization remaining under the facility, and all outstanding balances under the facility are to be paid on the respective due dates. On or before the end of each annual review, the lender will confirm to the borrower whether or not the facility is to be made available to the borrower following such annual review. This annual review fell due on 12th June 2018. Do you have any document to show that it was renewed prior to that date?
Renewal process takes some time, and it depends upon the documents submitted by the borrower. Bank asked.
Did the borrower, sorry, continue. I thought you finished.
And renewal, as I told, renewal depends upon the submission of documents, and as soon as they submit the documents, they are processed and put up before the competent authority, then a decision is taken.
When is the borrower, can I ask? When is the borrower expected to submit that request?
3 months in advance.
Can you show me any paper to confirm that the borrower D1 requested for such renewal 3 months prior to the expiry date of the facility agreement? It's during your tenure.
I don't remember that, but account was the business was running well, and party was in touch with the bank, and it was assured that your account is performing satisfactorily and it will be renewed.
So you don't know, or you're not aware whether any request for renewal is submitted or not.
Request for renewal or enhancement in 18, I'm not sure.
I'm not sure. The 2017 sanction letter, 12th June 2017. It's document H328 if you want it.
H what? H238.
H328, and I'm referring to H329, the next page in the sanction letter.
Yeah.
Mr. Kumar, you got it?
Yeah, got it.
Page H329, first paragraph. The facility will be due for renewal on or before 30/5/2018 and subject to our overriding right of suspension, withdrawal, and repayment on demand, including the right to call for cash, cover on demand for prospective and contingent liabilities for banking facilities, or otherwise to modify the facilities without consent of any party. So the due date for renewal was on or before 30/5/2018.
Yeah.
So if at all a request for renewal was to come from the borrower, it should have come before February 2018. 3 months, you said.
Yeah. May I give a chance to explain?
Please.
It is informed to the borrower that 3 months prior to the due date you submit their papers. But for various reasons, if borrower is not able to collect all those papers before 3 months and he takes some time, likewise, as you on 30th of May, the account was due for renewal, and as per 3 months by February, he should have submitted the documents. But for various reasons, if he is not able to give the documents, or some documents are have not been prepared, many times in Dubai, parties are out of country also for various reasons, for business reasons or for personal reasons also. So it may take some time, and it may 1 month or 2 months, or it is indicative that prior to 3 months prior you should submit.
So was it submitted at least 1 day before 30/5/2018?
Actually, I was not in on that date. I was not in Dubai, and I can't comment over that.
You cannot say. Now, whom do you call promoters of a company?
Promoters, the document as per documentary evidence, as well as the other operational matters also.
Promoters of a company. Whom do you call promoters of a company?
Who I can say who owns the company, or whose shareholding is there, maximum shareholding.
The shareholders of the company, right? The owners of the company. Yes. Do you know who were the owners of D1 at the time of granting these facilities?
Yeah, the shareholders were Velocity Ventures and Umaku.
At the time of granting. At the time of granting the facilities.
Yeah, and one local sponsor was also there.
What do you mean by local sponsor?
As per UAE law, one local sponsor is required.
Sponsor, are you sure?
Yeah.
What is the meaning of sponsor?
A sponsor means whose share will be, he will be the majority shareholder, more than 50%.
You mean a majority shareholder whose share is more than 50% is a sponsor. This is your understanding.
In UAE law, it is like that. The business practice is like that.
So it is the 51% shareholder. It is the 51% shareholder. You are calling him as a sponsor.
Yeah, it is as per country law.
Okay. So who was the 51% shareholder of this company? Because you did all the backdrop, business checking, all the due diligence of this company borrower before granting the facility. And you continuously did it every year before renewing the facility also. So who was this 51% shareholder?
Actually, the 51% shareholders, that's why he is called a sponsor. He has nothing to do with the day-to-day operations or business running. But as per law, I believe as per law, there is required any foreign nationals want to establish a company, then a local sponsor is required.
You understand it as sponsor, but he's a 51% shareholder. That's a mandatory national ownership requirement under the UAE law. Are you aware of the anti-fronting law? Anti-fronting law in UAE?
No, I am not aware.
Do you know the provisions in the company law which says that any such sham arrangement will attract penal sanctions up to 2 years imprisonment?
No, I am not aware.
You're not aware of it. You don't even know who is that 51% shareholder in the company.
No, I know. Name is here.
What is his name?
Can I read it out from document?
Please verify. Please verify. The name is written there. Mr. Kumar, Ali Hassan Abdullah Ali Al Raisi, who holds 51% of the shares. This is, I'm reading from the witness statement of Mr. Maniram, which you have stated in your witness statement that you are aware of all that is stated in Mr. Maniram's witness statement, and you confirm that. So paragraph number 14 of Mr. Maniram's witness statement says the 51% shareholder was Ali Hassan Abdullah Ali Al Raisi. Am I right?
You are right. Actually,
thank you.
The name is so long. Or,
did you take a personal guarantee from Mr. Al Raisi?
No.
The majority shareholder of the company. You did not take a personal guarantee. Have you done any background checking on him?
As per law, personal guarantee of local sponsor was not required.
Which law?
UAE law.
Which law specifically?
I can't say.
So you don't know?
Yeah.
You made a very assertive statement. As per law, it is not required. When you say that, you have to tell me which article of which law of UAE.
We are banking professionals, and for these things we have legal counsel. They advise us.
Do you withdraw your statement? As per law, it is not required.
Mr. Shaheen, it's perfectly legitimate for a witness to say that's his understanding without having to withdraw.
Your Lordship,
yes,
he said law, it is not required. I'm not aware of that law. I'm asking him.
Mr. Shaheen, he said he doesn't know, it's a matter for a legal department, but his understanding is that by law it's not required. I think it's clear.
Okay, I go to the next question. Have you done any background checking on the majority shareholder?
At the time of onboarding, it would have been done.
It would have been done. You're not sure.
I believe it would have been done.
Okay. Any document to show that it was done?
I believe it had been done at the time of onboarding.
Okay. Now, the other shareholder of B1, Umaku Trade Investment Limited. Have you checked the status of that company?
Yeah. At the time
Who are the
of
shareholders?
I'm sorry, I missed the name of the company. Mr. Shaheen.
It is one of the defendants here, D3 Umaku Trade Investment Limited.
Sorry, I misheard you. Thank you.
Excuse me. Actually, I just missed what's the, Umaku. Something there was Umaku. What was the question?
Was Umaku a shareholder of the borrower at any time?
Yeah, Umaku was a shareholder.
Okay. Have you done any background checking on Umaku?
Yeah.
Who are the shareholders?
Mr. Parag Gupta and Mr. Rajendra Makhijiani and his wife Devika Makhijiani.
What is the capital of that company?
I don't remember.
Don't remember. When you take a guarantee from anybody, do you check and ensure that it is within the means of that company or individual to pay that amount mentioned in the guarantee?
Yeah.
You do.
Yeah.
Now, 16.1, paragraph 16.1 from your witness statement. I state that the second to the 8th defendants provided the claimant the respective guarantees for the 2017 enhancement at exhibits. So the guarantees were provided for the 2017 enhancement. Am I right?
Yeah.
Do you know what is the limitation period of a guarantee?
As per my knowledge, in UAE, there is no limitation period.
There is no limitation period. Okay. In paragraph number 17, you have mentioned about the 51% shareholder. Right? Yeah. Do you accept photocopy of signature or signature copied and pasted by electronic means in your banking transaction?
No.
No. $20.1. The second sentence, starting from the middle of the third line, I submit that upon default, the claimant has the right to sue the first defendant and the guarantor, that is the second to 8 defendants, on the debt created by the loan and issue a claim seeking a money judgment on the debt. So when was the first default?
It was somewhere in the for which the claim persists. It was somewhere in, I believe it is in April.
Which year?
April 19.
2019. Are you sure? Before that, there was no default at
No,
all?
what I am what I told that for this claim.
No, I'm not asking for. I'm not asking.
Yeah.
Default. I'm asking about. You said, I submit that upon default, the claimant has the right to sue. So when was the first default is my question. If you are aware of it, tell me.
First default, I think it was in the March, July, August, like this in 2018. When I left Dubai, DIFC branch, then first default occurred.
So when did you leave the DIFC branch?
I left the DIFC branch on 18th of April, but before that, till 31st of March, I was actively working as Chief Executive Officer.
So March 2018, as per your witness statement, paragraph number 4, March 2018, you left the DIFC branch, and around that time, the first default happened. This is what you stated now.
No, I have not stated this. I am telling that till 31st of March, I was active CEO of that branch.
Okay.
But I have not left the branch. I left the branch of Dubai on 18th of April.
18th of April. Around that time, the first default happened.
No, at that time, default was not right. I believe that the TR or whatever facility was extended, that was defaulted in perhaps
Yes.
June, July, like this.
June or July of 2018, the default happened. I'm trying to come as close as possible to whatever you're saying.
Yeah. I believe I cannot ascertain the exact date.
I didn't ask for it. June or July 2018, the default happened.
Depends upon the due date or the maturity period of that payment.
Yes. Whatever it is, June or July 2018, the default happened under the facility agreement.
First.
Yes.
Yeah.
And according to your statement under 20.20, paragraph 20, I submit that upon default, the claimant has the right to sue the first defendant. I'm not saying you have to sue, but you said you had the right to sue the first defendant when the default happened under the facility agreement. This is your statement, correct?
Yes, correct.
21.
Can I say something in this?
Please.
Bank has the right to sue the
That's all I ask.
defendant, but it may be, considering the circumstances, he may not exercise that, because what happens? Let us suppose any default has occurred on 30th of June, and party is expecting, or he has informed that he is receiving late payment. The payment will come on 5th July or 6th July or like that 10th July, means 1 day, 2 days, 3 days or 4 days. Then bank will not exercise its such right.
As per paragraph 21, the bank continued to make the facility available until 29/9/2019. Your witness statement, correct?
I have to say something.
First answer, then you say.
No, what is the question? Sorry.
Question is, you said that in paragraph 21, the bank continued to make the facility available till 29/9/2019. Is that correct?
Yeah, correct.
Yes. Do you want to say something more? I'm trying to be as fair as possible to you.
Yeah, as I told, that it depends upon what is the circumstances. It never happens that if there is a 1 day default and bank goes to sue the borrower.
I did not say
So
that
like
you have
this,
to. Fine. Are you done? Can I go to the next question?
please.
Sure. Thank you. Can you read paragraph 22? Can you read it loud or you want me to read? It contradicts whatever you stated now about defaults.
No, that's fine now. The defaults were done, but as I told, it is not like that. As default has occurred and we just approach to court and we sue. Looking
Question
to the
was,
circumstances.
Sir, I have to interrupt you. My question was, when was the first default? I repeated the question many times. You insisted that it was June, July 2018. We came to an agreement that you said it was June, July 2018. You are not able to say the date precisely. But what you have stated in 22, paragraph number 22, I confirm that due to the default in the TR repayment on 21st March 2018, 5th April 2018, 2nd May 2018, and 10 May 2018, as confirmed by Mr. Maniram, the first defendant was in default of its payment obligation. So which is correct?
I want to clarify. These are the dates whose payments were defaulted. Means the TR which were issued on 21st of March 2018 was defaulted on due date. Similarly, the TR which was issued on 5th April 2018, 2nd May 2018, and 10th May 2018, they were defaulted on due date.
Okay. So the due dates were the default dates which you are shown in this paragraph 22. The due date for repayment were these dates you are shown in paragraph 22.
No, it is like that. What I told, that these are the dates on which TR were issued, and on due date of these TRs default occur.
You are talking about default in the TR payment. It is the default what you're referring there. It's not the issuance of the TR. The defaults were committed on these dates mentioned in paragraph 22.
I think it should have been more clear if it, instead of on, it would have been off. Sorry.
Not clear to me.
If it has been written like this, I confirm that due to the default in the TR repayment of 21st March.
Of 21st March?
Yeah, means the TR 21st March TR.
The whole sentence will not make sense then. That I confirm that due to the default in the TR repayment on 21st March 2018, 5th of 20, what do you mean by off there then?
Off
it
means,
will not make.
Off means here I mean to say that this TR due date and not this date.
TR due date for payment or TR issuance date? What do you mean?
Here the dates referred are the dates on which TR was issued.
TR was
issued and these were defaulted when due date came.
Okay, so the sentence in paragraph 22 stands incorrect. These were not the date of default.
As I told, these are the TRs which were defaulted.
So defaulted on 21 March 2018 or issued on 20th March 2018. You have to fix yourself in either one place. It cannot be both.
No, I am telling that TRs of these dates were defaulted.
TRs of these dates were defaulted.
Yeah.
Do you know when they were defaulted?
Different TRs may have a different maturity date, varying from as per the requirement, as per the contract between the party and the supplier. And it may be 30 days, 60 days, 90 days, whatever the contract.
So you don't know,
the purview
you
of
don't know
bank
the
center.
default dates. You do not know the default dates.
Exact. No, I am not sure.
Okay. And the statement as it stands in your witness statement is incorrect also. I'm reconfirming that.
You are interpreting it like that, but what I told, but this was the meaning I want to convey.
Okay. You say how much was the loan amount?
Means credit facility.
Yeah.
It was a TR facility of 6 million.
Totally almost $10.4 million, right?
Yeah, yeah.
How much is your claim amount?
My claim amount is, of course, I am referring to the witness statement. 2.288 USD million dollar.
It's only 22% of the facility amount. Around.
In percentage wise, we may say like this. Yes.
So why do you say in 23? I confirm that bulk of the loan remains outstanding.
Yeah. What happens when default happened, and despite party borrower assurance that funds are coming and we will adjust this, that, and substantial time lapse, I believe when the account turned NPA, then whatever the facility margin or cash collateral were there, they all have been appropriated, and that's why this outstanding came down.
So it's not bulk of the loan, only less than 25% of the loan, right?
After adjusting the collateral, it came down. Otherwise,
Okay.
we can say that it was a bulk amount.
And that also you don't have any direct knowledge because you're saying in 23, as stated by Mr. Manira. You have not
Correct.
verified.
Because I was not at that time in DIFC Dubai.
This is what we call hearsay evidence. Now, have you calculated compound interest?
Calculation of interest is taken care of by the system, by the software.
How does the system calculate it? Does it add interest to interest?
I believe it does. It adds.
It does. And how do you know the exact amount that is due? 2,288,367.42, because this was not during your tenure. How do you know the exact amount?
Yeah, as per Mr. Maniram's statement.
So it's again, you heard from Mr. Maniram.
Yeah, definitely. He was holding a responsible position, and whatever he is telling is, there is no reason not to believe.
Okay. And what is the status of the current account? How many current accounts in the name of the borrower?
Current account, only one current account can be in the name of the borrower. Other maybe overdraft account that some people term that account as current account. But overdraft it may be in the nature of overdraft.
Overdraft account is also a current account. It's not a saving account. It's not a term deposit account. It's a current account.
Yeah.
So what is the status of those current accounts in the name of the borrower? Are they still running?
Overdraft overdraft account, there is outstanding, then it will remain until we get the money from the borrower.
So you have not closed the current account.
No, why we should close? Unless we get the money, who will close it will be closed by the money only.
Okay. So question is very simple tag question. You can answer yes or no, then explain. Is the current account closed? The current account in the name of the borrower, is it closed?
No, but I want to add something. Please,
Yes,
permit
please.
me.
Please.
Yeah, if there is a debit balance in current account, then we cannot close that account.
Yes. So you cannot close the current account. The current account is not closed.
If there is a debit balance.
Thank you very much, Mr. Kumar. It was very helpful.
Thank you.
Thank you.
Right. Now, we may have a break, but who is going to cross-examine next? Is it you, Mr. Kapoor, or is it Ms. McGlone? Hello, I've lost everyone.
Your Lordship, if I may I don't think. Oh, sorry. Sorry, you can hear me now. I'm sorry for the
Yes.
echo. Your Lordship, at this rate, we will never complete the trial in this 5 days. We are way beyond our time. Parties are taking a very long time.
This is the point I made at the beginning.
Cannot then.
We'll finish this witness probably tomorrow, and then we will discuss it. But meanwhile, I hope parties can discuss it. We'll need at least 3 extra days. The timetable is ridiculously ambitious, it seems to me.
Lordship, and in fact, the third witness, I think, may take longer at the rate at which the witness number 1 and 2 have been cross-examined, because the relevant default is with the third witness period. And if it is cross-examination, I'm assuming if I were on the other side and if the rate at which it has gone for witness 1 and 2, it will go on much longer for witness.
I said we'll discuss this tomorrow. We'll discuss it tomorrow. When I say we'll discuss it tomorrow, it doesn't mean let's discuss it now. Okay? Right. Who is going to go next, Mr. Kapoor or Ms. McGlone? Have you discussed it? Mr. Kapoor, are you planning to go next?
Well, I can. In fact, if Zara wants to go first, I'm okay with that. But otherwise, I can go now.
I'm happy to start, my lord.
Right.
Okay.
Well, Ms. McGlone, happy to start, but we've been.
Yes.
We've been a while over this witness. Do you want a 10-minute break or 5-minute break?
My
Or
lord,
will the witness?
I'm conscious that your lordship said yesterday that he would need to rise at 2 o'clock UK time.
Yeah.
Yes, and so in light of that, I think it's sensible to press ahead, given that the court will have to rise in 20 minutes anyway.
Okay. Actually, I hadn't noticed it was that time. Yes. Well, let's continue now. And Mr. Kumar, you're going to face some questions from Ms. McGlone, okay, who acts for the 6 to 8 defendants. Right, Ms. McGlone.
Good afternoon, Mr. Kumar.
Very good afternoon.
Good afternoon. You've already explained that you were the senior executive officer for the DIFC branch of UBI from February 2015 to March 2018. That's correct, isn't it?
Yeah.
And during that time, you were authorized by the DFSA, weren't you?
Yeah.
And you understand that that meant that you had to observe high standards of integrity and fair dealing, don't you?
Yeah.
And it also meant that you had to act with due skill, care and diligence in carrying out your functions, didn't it?
Sorry, can you repeat it?
Of course. It also meant that being authorized by the DFSA also meant that you had to act with due skill, care and diligence in carrying out your functions. That's correct,
Ye-
isn't it?
Yeah.
Yes, it is. And you confirmed earlier that you don't have any direct experience of any of the events in this case which took place after March 2018. That's correct, isn't it?
Yeah.
Yes. Now, first of all, I'd like to look at some of the previous agreements in this matter. Now, the 2014 facility with D1, I appreciate that that was before your time, but oh, Mr. Kumar, you have disappeared from my screen. Oh, you are there, good.
Actually, there is some issue and the system is flashing. I turn off the video for better quality sound. I didn't do that, but I just put my ear earbud.
Mr. Kumar, I'm very grateful to you for explaining, and I'll bear those difficulties in mind. As I was just saying, the 2014 facility was before your time, but it ended once you were in post in the DIFC. Now, were you in court for Mr. Chezian's evidence earlier?
Yeah.
You were. So you will have heard him agree that the availability period for the 2014 facility commenced on the signing date of that agreement, which was the 18th of March 2014, and it terminated on the final maturity date, unless it was otherwise extended. Did you hear him agree that?
Yeah.
Yes. And he also agreed that the final maturity date would be 12 months from the date of the agreement, again, except where it was extended. Did you hear him agree that?
Yeah.
Yes. So in those circumstances, the 2014 facility agreement, which started on the 18th of March 2014, ended on the 18th of March 2015, didn't it?
No, as I told that it doesn't happen that on the date of expiry, the limit is withdrawn overnight. If
I appreciate
we are
that.
in the
But just in terms of the provisions of the agreement, they do say that the agreement may be extended, and presumably that's to allow for that sort of situation to arise. But the starting point is that it will come to an end 12 months after. And Mr. Chezian agreed with that earlier. Do you agree with what Mr. Chezian was saying?
Yeah, it is correct. I agreed. But at the same time, if there is a process of renewal going on, then we cannot construe that it is ended on that day.
Sure, and that's why there's a reference in the agreement to the possible extension. It's in the agreement. The agreement allows for that. Now, Mr. Chezian also confirmed earlier that where there is a change in the facility or an increase in the facility, there needs to be a new facility agreement. And that's correct, isn't it?
Yeah, when there is a change in facility or enhancement, press facility agreement is required.
Of course. Could I ask you, please, to go to H187 in the bundle, please?
Which one? H?
H for hotel.
H?
H for hotel.
H187.
187, sorry.
187. Yeah.
Is a sanction letter.
Yes.
Yeah.
So this is a sanction letter dated the 13th of July 2015. Can you see that date on the top right hand?
Yeah.
Yes. Yes.
Yeah.
Now, earlier, Mr. Chezian, and I think subsequently you, agreed that a sanction letter is a precursor to a facility agreement. That's correct, isn't it?
Yeah.
Yes. Now, at paragraph 12 of your statement, you say that enhancement, you confirmed you signed the sanction letter, G219, if you're looking for the relevant paragraph.
You are referring to my witness statement?
Yes. You simply say that you signed the sanction on behalf of the claimant in order to enhance the facility.
Yeah.
Yes. But in order to enhance the facility, you would also need a facility agreement, wouldn't you?
Yeah.
Yes, yes. No. And in order to have a facility agreement, you would obviously need to have the company's agreement to that agreement. That's correct, isn't it?
Yeah, facility agreement is required, but this sanction was conveyed to the party, to the borrower, but he informed that they are coming with some other plan and some more facility is required. That's why that facility agreement was not executed for this sanction.
Yes, exactly, exactly. So this sanction letter was offered, if you like, to the borrowers, but it wasn't accepted by them, was it?
No, it is not like that.
But it's, Mr. Kumar, can I ask you to go, please, to page H193.
Yeah.
Yes, you're there. And we can see your signature there on that page, can't we?
Yeah.
Yeah. If you go onto the next page, page H194, and indeed the next page after that, H195, there are no other signatures there, are there?
Yeah, fine.
But that was my question, Mr. Kumar. That was my question, and you've answered it, and I'm grateful. If you have other things to say, they may be covered in re-examination by your counsel in due course. Now, it's the 6 to 8 defendants' position that the terms of the 2015 sanction letter were not accepted by D1 or by them. And indeed, as you've explained a short while ago, in order to have an enhancement of the facility, as the 2015 sanction letter indicates, a facility agreement would be required. So on your own evidence, where there isn't such an agreement, either in the form of a facility agreement or indeed in the form of a signed sanction letter, there isn't an agreement in the terms of that sanction letter. That's the 6 to 8 case on this. Now, if we could turn. Yes.
I need to respond.
It wasn't a question, Mr. Kumar, but if you.
But it shouldn't. If it wasn't a question, it shouldn't have been asked.
But if you would, that's the 6 to 8 defendant's case, which is why I'm putting it to you, Mr. Kumar. Now, if you would like to comment on it, please do so.
Yeah, this sanction was conveyed to D1, to the party. These facilities has been approved. Here, there was some enhancement. At that time, party, I believe party has come across and some more fund requirement was there. That's why they came up with that we need some more amount, more credit facility, and we are not going to take this whatever enhancement. I remember that facility was given for additional term loan of $600,000. Party informed that they need more than this, and they given us a new requirement. That's why this facility agreement has not been signed, but the earlier facility agreement that has been executed was continued.
Mr. Kumar, I believe you've just confirmed what I was saying, which is that D1 didn't accept this sanction letter. That's why there was no facility agreement pursuant to this sanction letter, because their requirements were different. That's what you've just said, isn't it?
For which they put another request.
Precisely, and that's what we're about to come on to. If we can go then to the 2016 sanction letter and facility agreement. Now, if we could start, please, at H197.
Yeah.
Yes. Now we see that this is dated the 21st of March 2016, isn't it?
Yeah.
Yes. And if we go to the end of that sanction letter, to H201, yes?
Yeah.
Yeah. We see your signature again.
Yeah.
And then if you go over the page to H202, and then indeed onto H203, we have the signatures of the other parties, don't we?
Yeah.
Yes. And following that sanction letter, we have the 2016 facility agreement. Could you please go to H240? Mr. Kumar, are you there?
Yeah. Just I am
Great.
scrolling down.
Oh, I see. If you could let me know when you've reached that page, that would be helpful.
Yeah.
There. And we can see that that's dated the 19th of April 2016, isn't it?
Yeah.
Yes. You just go over the page onto H241.
Yeah.
Now, if you look at the bottom left-hand corner of that page, you can see what appears to be a number of signatures, can't you?
Pardon, I couldn't get left
Sorry,
side.
the bottom left-hand corner of H241, there's some handwriting, isn't there? And those appear to be signatures, don't they?
Yeah.
Yes. Do you know who those signatures belong to? Just looking at them now.
One is Mr. Vijay Kapoor. One is Mr. Rajendra Makhijani, Ms. Devika Makhijani, and another one is, I believe it is Ravi Kuchmanchi.
Could we please go to page I61 in the bundle? And again, just let me know when you're there.
I-60?
1.
Yeah.
You there?
Yeah.
Yes?
Yeah.
Now, Mr. Kumar, this is a page from the account opening form for D1 in 2014. And as you can see, towards the bottom of that page, we've got the heading specimen signatures. Do you see that?
Yeah.
Yes. And then we have a specimen signature for each of Mr. Kapoor, Mr. Gupta, Mr. Kuchimanchi, and Mr. Makajani. Yes?
Yeah.
Yes. They're not exactly the same as the signatures which were on H241 and which we saw a moment ago, are they? I'm not saying that they're not the signatures of those individuals, but they don't look exactly the same, do they?
Yeah, it is like that.
No, they don't look exactly the same though, do they? If you
Yeah,
look at those signatures and then you look back at H241, they're not identical to each other. I'll have time to go back to it, yes.
Is there a method of putting two pages out side by side?
Unfortunately, my lord, I'm not sure that there is. I have the benefit of hard copies of the bundles.
Right, thank you.
Well, yeah. You mean to say that signatures are different?
I'm not suggesting, I want to be absolutely clear, Mr. Kumar, I'm not suggesting that the signatures on the 2016 facility agreement are not the signatures of D4, D5, D7, D6 and 7. I'm just suggesting or pointing out that as they appear on the 2016 facility agreement, they're not exactly the same as the specimen signatures. That's the point I'm making.
What happens when you have to sign a series of a number of pages, you have to sign 50, 60, 100, more than 100. Then it always, there is a difference.
Absolutely.
And the person who is signing the document before you, then I don't think there is any doubt that I should take that.
I understand that, Mr. Kumar, but the point you're making, I think we're agreed. And that's one, that people's signatures aren't always exactly the same every time they write them, are they?
Yeah.
On that, Chair.
A good place to break.
I thought it might be. Let's resume tomorrow. I think it has to be 9 o'clock tomorrow, or 12 Dubai time, unless Mr. Shaheen's arrangements have changed. No, 9 o'clock. And can I ask parties in the meantime to have some discussion between themselves as to timing, how long realistically they need, and can at least make some provisional exploration about dates and whatever. Okay, 9 o'clock tomorrow morning, 12 o'clock Dubai time. Thank you.
Thank you.
Thank you very much, Lord.